A bench led by Chief Justice of India UU Lalit has asked the centre to make its stand clear on the contentious Places of Worship Act enacted in 1991 by the Congress government of Narasimha Rao. The centre has been given a maximum period of 2 weeks to clearly place its stand before the top court. Most critically, during the hearing, for the first time, the centre's lawyer, Solicitor General Tushar Mehta, has let his mind be known on his stand on the Places of Worship Act of 1991. The act was brought in to bar Hindus from making claims upon Kashi, Mathura, among other disputed sites where their places of worship have either been desecrated or built over in successive waves of settler colonization. In the course of the hearing on scrapping this law, the Solicitor General disagreed with those that claim that the Ayodhya judgment had upheld the sanctity of the Places of Worship Act, and therefore the Supreme Court need not entertain the petitions by Hindu rights groups. Now, what are these Hindu rights groups, viewers, asking for? All they want, in some instances, viewers, is access to their places of worship. As you can see, viewers, in Kashi, a mosque has been built over one of the holiest sites of the Hindu faith. It is so apparent, viewers, that it doesn't require any ASI investigation to determine what stood under this mosque. The remains of the Grand Kashi temple are very clearly visible. This was an act of desecration intended to show Hindus their place. Now, viewers, this is not the only site. The Krishna Janam Bhoomi in Mathura also has been in some ways built over. Viewers, there are many, many more temples such as these. Now, when a law that forbids Hindus from accessing their places of worship is passed by Parliament, I agree, viewers, that the law freezes in time claims over these disputed sites, saying that after 15th of August 1947, no religious sites status can be changed. Now, this applies across the board, but remember, overwhelmingly, it dents or affects the prospects of the Hindu community the most, because the Hindus are in a majority in this country. And settler colonialists specifically singled out Hindu places of worship more than others. So, viewers, how can, in a secular nation, the rights of one community be seconded to the rights of other communities? And this is fundamentally where the problem lies. And those that don't want to grant Hindus the right to access their places of worship are saying that the Ayodhya judgment that came out a few years ago, viewers, the 5-judge bench, actually upholds this Places of Worship Act that was promulgated in 1991 by the Congress government of P.V. Narasimha Rao. Well, the bench today asked the government's lawyer to opine on the issue, and Tushar Mehta said that the Supreme Court's remarks in Ayodhya case are not relevant to the present hearing on the petitions filed by Hindu activists seeking to reclaim disputed places of worship like Kashi and Mathura, along with several others. Viewers, Mehta's views may indicate the stand that the centre may end up taking in the top court on or before October 31st. But let me tell you first, viewers, what the ecosystem has devised to block Hindu claims over their place of worship. So many stratagems. It enacted, viewers, the Places of Worship Act, 1991. The act barred Hindus from reclaiming Kashi, Mathura. Claimed Ayodhya verdict upheld the Places of Worship Act in 1991. And there on your screens, UU Lalit says, let's go back to that once. UU Lalit asks, this is the Chief Justice of India, what is your personal view regarding the impact of Ayodhya judgment on this challenge to overturn the Places of Worship Act? Tushar Mehta says, it may not be covered by that. And he elaborated in a few more sentences. Now viewers, let's have a very quick look at the arguments of the two sides. The petitioners, the Muslim side, the court, etc. Now, you will all remember, viewers, that this entire matter has been brought up before the Supreme Court by Dr. Subramanian Swamy, and I want to bring him in first because he is one of the main petitioners. Now, Dr. Swamy, the first question to you is this, that you are someone who is stoking communal passions, that's what is said, by wanting to revisit these claims, these cases of Kashi and Mathura, that you will create in some ways communal strife. So what is it that you are, sir, arguing, and why is it that you are bringing this claim forth now?
Oh, thank you. First of all, congratulations. Your introductory remarks were very good, very concise and accurate, and I think it will help the audience to put the matter in perspective. See, the issue is these are not new demands. It's not also a new demand for me. This Places of Worship Act came in Parliament in 1991, and I was a member of Parliament. And of course, I was that time president of the Janata Party, and there was a separate party which had been formed called BJP. And both I and the BJP MPs walked out of the house because Narasimha Rao was refusing to consider two other things to be included, not only Ram Janmabhoomi. By the way, this bill came and got passed before the demolition of Babri Masjid. That took place on 6th of December 1992. And this was passed in sometime in July, August of 1991. Now, the key question is this. What is the claim of what I would call as the rational Hindu hardliners? I would call them hardliners, of course, because they are sticking to their guns. But I would call them rational because they've got logic. They say that only 3 of the 40,000 temples demolished is what we want restored, of which one is now being restored, that is the Ram Janmabhoomi. And 2 others, that is Mathura, Krishna Janmabhoomi temple, and the Kashi Vishwanath temple. Now, why is it that we are restricting it to 3 and not all the temples? Of course, there are hotheads, there are people who say, no, all the 40,000 temples have to be recovered. And I explained why in sobriety we should not go beyond 3, and of which now 1 is done. Actually, it was 4 in 1947, but Sardar Patel couldn't care less about anybody, so he restored Somnath temple, which is also a Jyotirling temple.
Yes.
Despite Nehru's opposition, but he was supported by the President of India, he was supported by a very large number of people, and he got it done. So from 4 we came down to 3, and then now down to 2. Now these 2 are places where God has something to do with the temple being formed. Krishna was born there, not anywhere else. There is no other claimant to Krishna being born in any other part of India or the world. So that is a unanimous view for centuries, that Krishna was born there, and the temple was built, which is Krishna Janmabhoomi temple, which was demolished on the orders of Aurangzeb, and a mosque built on top of it. I mean, that was the atrocity that was committed. And so we want that temple to be revived. It should be constructed again. Why? Because there is no other place I can go to worship the birthplace of Krishna. Just as the argument I used in Ram Janmabhoomi, which started the whole discussion in the Supreme Court after 8 years of no action on appeal from the Allahabad High Court. I brought this as a fundamental right question, that my faith says that Ram was born there, and there is no one to contradict me on this. Everybody agrees. So when I have a fundamental right to pray where Ram was born, I need to make a case to get back that land. That's how the whole proceeding started, and that's how it concluded. Yes. And to the shall I say, I would like to praise the Muslim community. They agreed, and they took 110 acres in what is now called the Ayodhya district, and they are building a lovely masjid there. Masjid is essentially not a religious structure. It is a place to read namaz. Anywhere and everywhere you go to any Islamic country, they are demolishing masjids on a regular basis to build roads. All you have to do is go to Google and type masjids or mosques being demolished by various governments, and they'll give you the list fully, and which I had presented to the Supreme Court also. So the Muslim community cannot say, oh, it is equally sacred for us. It's not sacred. It's a place, it's a congregation place for reading namaz, and namaz can be read anywhere. They can be read on the road, can be read on the aeroplane, and in your drawing room, etc. So to compare a mosque with a temple, in my opinion, is blasphemy, and I cannot accept it. So we are now saying only these two. And you can build a mosque somewhere nearby. But then why not the others, which 40,000 were demolished during the Islamic period? Why are we not claiming those? Because those are not area specific. In other words, the idol is sacred because of Prana Pratishtha Puja, but the temple place where it stands is not sacred. Okay. So you can have the same murti in another place. So and there are so many Ram temples with Ram in it, but they are not. Yes?
I want to ask you this, Doctor.
So I'm just concluding by saying.
Yeah. Yes.
No,
I just want to ask you, I know you made this big differentiation. You made this differentiation between the 40,000 yes. or what have you, others, and these two. But if tomorrow the Supreme Court was to overturn or scrap the Places of Worship Act, then
yes.
potentially
yes.
Hindus can
yes.
reclaim just about every temple, isn't it?
One remark of the Chief Justice you missed. Mm-hmm. He asked me, are you saying that if these two are put in that category with the, see there's a category of Ram temple being exempt. Mm-hmm. So I say that's an arbitrary decision, so you add these two also and let the act remain.
Okay.
The act need not be scrapped, and only that section 4 need to be, and the section 5 should be amended, and these two temples should also be included, that except that this applies to everybody else. And so then this problem of other temples will not come, there will be no chaos, there will be nothing of the kind. And I would say 95% of the Hindus will accept this.
Okay.
There will be some hotheads who would say anything they want, but the government has to put that down strongly. And we can't go too much back in our history. So these two temples we can't give up. And that has been the position of all the sadhus and sannyasis since 1964, when the sadhus met in Delhi and decided that we want only 3 temples, not all the temples. So I think the problem has a solution, and the Muslim community should come forward and accept it.
Thank you, Dr. Swami. Thank you for putting this in context, and best of luck. The centre, of course, has to respond by the 30th or before the 30th. Let's see what the centre says. They're on test, really, viewers, because as I said, as I began by saying, that in secular India, you cannot have a communal law, viewers. You cannot have a law that only militates against overwhelmingly the claims of one community. And how can, therefore, this inequality be secular? Of course, Dr. Swami says that the exemption must be applied to 2 more temples. There are others, of course, who believe that no, there should be no such stipulation, that Hindus should be able to reclaim from their civilizational oppressors all their fundamental temples or other monuments, etc., that they believe are integral to their faith. Now, that's a larger argument, and I'm happy to indulge our panelists tonight, and let's open this up in that. But let me first begin by asking a question of Lokesh Jindal, leader of the Congress party here, who is with us. Mr. Jindal, how could the Congress in 1991 have passed or contemplated a law that overwhelmingly denies Hindus the right to reclaim their places of worship? And how did you propose that this particular law is a secular one, when it differentiates, when it militates against the basic rights that are guaranteed by the Constitution, fundamental rights? And you know, right after that, notifications were issued barring Hindus who had been going and praying at the Gyanvapi Mosque and the Kashi site there for centuries altogether. What was the Congress's problem with the community?
Good evening, Rahul. When we talk about the Constituent Assembly, which was framing the Constitution, at that point of time, a major question emerged as to what shall be the nature of the Constitution that shall govern this entire country. At that point of time, almost all the lawmakers, they agreed that in order to have a secular form of Constitution, it is important to have positive safeguards given to the minorities which are vulnerable, because in a democracy, there could be the rule of the majoritarian. Subsequently, the Article 25 till Article 30, it implicitly aimed at creating a secular fabric to the country, to the nation, so that the rights of the minorities, they could be safeguarded, along with the majorities, they also enjoying the rights. The point is, Rahul, we cannot expect one community to enjoy their rights, thereby trampling over the rights of the others. However, your argument is that the Places of Worship Act 1991, it gives rights to the Muslims and it takes away the rights of the Hindus. That's what you state. But please understand, Hindus and Muslims, they are not equal in this country. I mean, Muslims, they are numerically inferior. They only constitute about 18% of the total population. And moreover, the Hindus, they are majoritarian. I mean, on all bases, social, economic, cultural front, they are at a relative advantage over this community. So I would state over here that the positive discrimination that has been the policy of the state, it must be respected, and the secular fabric of the nation must be preserved.
Okay, let me bring in Jesai Deepak. 91 was introduced. Let me bring in Jesai Deepak on that point. He says the secular fabric, and I just want you, Mr. Jesai Deepak, to bear with me. I'm reading out what Mani Shankar Iyer, in the course of the debate, had said in 1991 on the floor of the Lok Sabha. He said, when I come across a temple and a mosque together, then I feel that this is a secular country. I will request you, please listen. You too will get a chance to speak. Let me speak that I believe that this is a secular country and that spirit of secularism is being upheld. How do you respond to the charge, and of course to what Lokesh Jindal is saying, is that those like you, like Dr. Swamy to different degrees, who want to overturn this 1991 act are actually acting against the spirit of brotherhood, etc.?
So, Rahulji, so just a few clarifications. I am not appearing in this matter in my personal capacity as a petitioner, although I may have my own views on this particular legislation, which are fairly clear and categorical and firm.
Yes.
I represent the Kashi royal family with respect to the Rabia Mosque, which was demolished by, the Razia Mosque, which was demolished by Razia Sultana, so to speak. That is the specific issue that we have raised there. Now, before I proceed to respond to Mr. Jindal's position, please note that while I respect Dr. Swamy's erudition as well as his sagacity, I have very clear disagreements with Dr. Swamy on the position that he has taken with respect to only exceptions being made for Kashi and Mathura on par with or at par with Ram Janmabhoomi, because in my opinion, that is not legally possible, because it's not possible for you to ask the court to read into a legislation extra exceptions which the legislature did not intend. To say that there are certain other exceptions, that too ought to have been included. That's point number one. Point number two, none of us can make concessions on behalf of the actual title holders with respect to each of the properties, because like Ram Janmabhoomi, principle of title suits will apply to each of these places. It is for the right owners to make those concessions. Third parties cannot make these concessions. So that's not possible. Now, whatever anybody may have decided at some point, that cannot be given the scope or let's say the status of a legal agreement, because nobody has entered into any such agreement in representative capacity on behalf of Hindus. Nobody has given them anybody the power of attorney as far as this issue is concerned. This is a legal statement. I'm not making a sarcastic or a rhetorical statement. Okay. Three. Now, whether this amounts to a hot-headed position or not, I cannot comment on that simply because I'm representing a particular party here. And I believe that each party has a legitimate right to seek the repatriation of its own property, and that wouldn't amount to hot-headedness. That is my limited submission. Now, on Mr. Jindal's point, please note, I think the word secularism is perhaps the most abused and, let's say, disabused word in the entire, let's say, English dictionary as far as the Indian discourse is concerned. Secularism, when stripped to its most basic fundamentals and its conceptual doctrine, stands for what? That the state shall not take a specific or adopt a specific religious position, will not have a religious character of its own, and therefore it shall stand equidistant from all religious identities. Now, in this case, therefore, what are we saying? Please do not stand in the way of the legal remedy of one particular community to approach the court through the, let's say, through the option of Article 32 or through suits, because when the state actively stands in the way of judicial remedies, it amounts to curbing that specific fundamental right. And Rahulji, since you have participated in several legal discussions as part of your debates, the right to approach the court for enforcement of fundamental right is itself a fundamental right. Okay? And therefore, when you use a legislation to stifle, snuff out, and completely abrogate that particular right, that is the state, the so-called secular state, taking an anti-secular and unsecular position which stands in the way of my religious rights to protect the usurper's rights. That is the textbook definition of being unsecular. So this majoritarian nonsense, this minoritarian nonsense, none of this has got anything to do with the definition of secularism. Like a Congress spokesperson, I understand, will have his fundamentals as far as secularism completely muddled. I have no doubts about it. No wonder we are where we are in terms of the legislation continuing to stand. Now, the point Dr. Swamy made with respect to Mr. Tushar Mehta's submission is bang on the point, which is absolutely right. Because you see, as far as Ram Janmabhoomi judgment is concerned, one of the arguments that we have also raised and others have raised is that there was no occasion for the Supreme Court to deal with the Places of Worship Act in the context of Ram Janmabhoomi, because that specific dispute was excluded from the scope of the legislation. So why will you discuss the legislation? When you discuss something that has got no relevance to the issue at hand, it is known as obiter dicta, meaning thereby it has no binding value. But there is something else which most people missed out, which I actually pointed out during the course of my submissions today. The reference to the Places of Worship Act in the Ayodhya judgment of the Constitution bench is based on a completely erroneous reading of the 3-judge bench of the Allahabad High Court. So whoever the author of the Ram Janambhoomi judgment is, we still don't know, because no particular judge said that I signed it. It's been commonly signed. We still don't know who the author is. That's not relevant, of course. I'm just saying we don't know. Effectively said that Justice D.V. Sharma, who was a member of the 3-judge bench of the Allahabad High Court, has referred to the Places of Worship Act, and therefore it falls upon us to take a look at that particular discussion. If you read Justice D.V. Sharma's judgment, and I've written a 2-part piece on this in the New Indian Express and several other places immediately after the pronouncement of the verdict, Justice D.V. Sharma did not make a reference to the Places of Worship Act whatsoever. In fact, as part of his discussion on whether fundamental rights can be asserted by way of civil suits, he was extracting a 1995 judgment of the 3-judgment of the Supreme Court, where there was a discussion on the Places of Worship Act. The Supreme Court mistakes this for a reference by Justice D.V. Sharma, makes that the pretext for a discussion of the Places of Worship Act, and then goes on to write 10 pages on how the Places of Worship Act effectively protects secularism, which happens to be the basic feature of the Constitution. Therefore, one of the submissions that was presented before the court today was that the Ayodhya verdict is factually incorrect insofar as its discussion on the Places of Worship Act is concerned, because apart from the fact that the act does not apply to Ayodhya, there was no occasion. It was completely based on an erroneous reading of the Allahabad High Court itself. So therefore, to answer Mr. Jindal's position, he may perhaps have slapped a few basics around in describing what is secularism. This legislation is the textbook definition of what is an anti-secular legislation, because it supports the right of one community over the other without giving sufficient reasons for the same.
Also, let me tell you, viewers, that even if the Supreme Court had decided to pronounce some sort of binding verdict on the Places of Worship Act, it couldn't have done so. It would have been in contravention of its own rulings, because in Director of Settlements, Andhra Pradesh and others versus M.R. Appa Rao and another on 20th March 2002, the Constitution unequivocally indicates that the law declared by the Supreme Court shall be binding on all courts within the territory of India. The aforesaid article empowers the Supreme Court to declare the law. It is therefore an essential function of the court to interpret a legislation. The statement of the court on matters other than law, like facts, may have no binding force, as the facts of two cases may not be similar. But what is binding is the ratio of the decision and not any finding of fact. It is a principle found out upon a reading of a judgment as a whole in the light of the questions before the court that form the ratio, and not any particular word or sentence. To determine whether a decision has declared law, it cannot be said that be a law when a point is disposed of on concession, and what is binding is the principle underlying a decision. A judgment of the court has to be read in the context of the question which arose for consideration in the case in which the judgment was delivered. So very specifically, the Supreme Court itself has said that a judgment of the court has only to be read in the question, in the context of questions which arose for consideration. In the Ram Janambhoomi issue, there were a few specific questions that arose for consideration, and they only had to do with the Ram Janambhoomi, not anything to do with any other matter, and therefore only the court can only rule on those specific points, or no other. Now let's open this up, because we've established, perhaps viewers, that a grave inequality persists here. As J. Sai Deepak has told us, what kind of state denies any person the right to approach the court? Fundamentally. So let me bring in another lawyer, Syed Rizwan Ahmed, and I also want to bring in Danesh Qureshi. Mr. Ahmed, I want to ask you, why would the Congress come up with a law that denies Hindus overwhelmingly? Because let's face it, it was Hindu properties, Hindu places of worship that were majorly affected. Why would therefore the Congress contemplate bringing in a law that denies Hindus principally the right to approach the court in the first place? Mr. Ahmed.
Thank you so much. Jai Hind, Vande Mataram. Yeah, see, more than denying Hindus their right to approach the court, I think it is more a matter of appeasement of Muslims. rather than discrimination against Hindus. I think it was an appeasement for the Muslims, number one. Number two, we were talking about secularism. What I feel, I'm not a constitutional expert, that secularism and minority, both the words cannot go hand in hand in the same constitution. This I have been reiterating from the last 5 years. It is a constitutional oxymoron. When we had equal law for all in the constitution without using the word secular, and we were treating all the citizens equally, and the government did not have a official religion, we should have waited to see how things transpire and how things unfold. And if there would have been circumstances or occasion or ground to safeguard the minority in this Hindu majority country, then we should have made this constitution secular, or else both the things cannot go together. If you need the word minority, you should have a religious state. India could have been a Hindu Rashtra, which was a pluralistic society safeguarding the minorities. Then it would have been correct as far as I think. Now what Mr. Sai said, that he is not on the same page with Dr. Sahab, I also don't agree when he said that we will have these three issues, three temples. Sanatan Dharma is a very large belief, a very vast belief. You cannot say that all the main gods existed in this part of the country, which is now present day Uttar Pradesh. I was talking to a guy yesterday, he said we are not celebrating much Holi or even Diwali back down south. So the point is, Muslims, they captured and conquered Pan-India. They violated Pan-India. They ransacked Pan-India. So how can Mr. Subramaniam Swamy as an individual say that all other temples are irrelevant, and he went to say that the government should come out very hard against those people who are not seeking relief other way. See, anybody can say this temple in Karnataka is important for me more than Ram Janambhoomi and more than Krishna Janambhoomi.
No, Rizwan Sahab, I think what he was saying is that the government should define its position in hard terms. That's what he meant. Not take action against those people who are coming to court. I think that's what he meant. He said that the government should come up with a very firm position on this. Yeah. Anyhow, that's a different matter. I understand. That's a different matter. My point is, do you believe that the Supreme Court today, the Supreme Court today has taken a leap forward in deciding upon this matter by getting the center into it, and should perhaps parties like the Congress, etc., now come out and support the granting or the petitions where the Hindu side are saying that, look, at least give us the right to approach the courts, if nothing else. Rizwan Sahab.
Rahul, my humble submission is, though I am not a Supreme Court lawyer, but with prudence and as a lawyer in Lucknow, I can tell you one thing: it is a very precarious situation which perplexes me. See, what I feel, and note the date today, I really do not feel that Act of 1991 will be absolutely abrogated.
Okay.
I really don't think so, that the government of the Supreme Court will open the gates absolutely for suppose 2000 petitions to come pan-India. Number two, it is very difficult for Supreme Court and the government to define that we are confining this act, limiting this act to 3, 4 or 5 places. So I really cannot put my submission in that. What will the Supreme Court do? Yeah.
Let's not presage that. I'll come to J-Sai Deepak at the end on looking at perhaps what the center can do now. But let me very quickly go across to political analyst Danesh Qureshi, who's a sympathizer of also the MIM. Mr. Qureshi, you have a situation here where one particular community is shackled by the law which was passed clearly, and let me tell you, the father of Asaduddin Owaisi, Sultan Owaisi, came out and backed the Places of Worship Act. In the Lok Sabha, he gave a long speech just before the bill was introduced for vote. Now, why would you want to disenfranchise your Hindu brothers. Why would you want to do that? Why wouldn't you want them to at least, on the face of it, get justice? Not from you, but from history.
Rahul, first of all, I am 100% disagree with Mr. Subramanian Swamy what it is said. He said to be excluded one of the place Mathura and second in Kashi. First of all, we talk about the judgment on verdict on Ayodhya. What was the Supreme Court stated in that? That the Places of Worship Act will be the part of the basic structure of the Indian Constitution.
No, sir, please.
And after that, they started all things.
Danesh Saab, now you are again, one second. You are playing fast and loose with the facts.
Don't interrupt. Did anybody has clarified that? Did anybody has defined the place where God Ram was born? No, nobody. And once again, the Krishna Janmabhoomi is being claimed. Kashi Mathura is being going to claim. What do you want? They want this time 2 places to be excluded from the Places of Worship Act. After these 2 places, they will come up. We need 5 more places or 100 more places to be excluded. Then, if we want to exclude time by time or series by sequence, then what is the meaning of this act? We have to understand that at that moment when Supreme Court has given verdict on the Ayodhya, what was the Supreme Court was stated that we don't want that this such types of matter should be entertained by the Supreme Court.
Saab, I don't think you've read the judgment. First of all, you are completely massacring what the judgment said. Please don't do that. First of all. Secondly, AIMM came out and said at that time that the Supreme Court's judgment on Ayodhya is flawed, that the Supreme Court, and this was the implication, that the Supreme Court itself was, at some level or the other, forwarding or furthering the cause of a Hindu Rashtra. This is what was said. Now,
don't go that, Rahul. I want to ask you, did anybody have defined
you said it was faith over facts. No, 1 second, sir. Please let me finish. It was faith over facts that the Supreme Court had put faith over facts. Now, let me ask you, sir, you are so dismissive of the Hindu faith.
Nobody is dismissive.
Nobody is dismissive. You just said, किसने देखा कि राम कहाँ जन्म हुए? You just said, who knows where Ram was born or Krishna was born? Sir, this is a matter of faith. You take your matters of faith so seriously that even if someone were to question them, a whole brigade of people jumps onto the streets and says Sartan se juda and all this.
Okay,
Rahul, I think that is not fair.
What did you accept that?
If another faith, if another belief system has certain,
can the Supreme Court give the judgment on the faith beyond the facts?
Danesh Saab, please, that's not fair, because they went into the Supreme Court in the Ayodhya Ram Janmabhoomi case, went into sir, the title. They went into the title. You came out and deliberately obfuscated and suggested that the Supreme Court has saffronized.
Rahul, I want to reply from you. Once again, we will go on the basis of faith instead of fact.
Danesh Saab, titles will be examined.
What titles are we going to examine?
That is what has happened. Anyhow, 1 second. Okay, listen, sir, I understand. Sir, you are sounding like one of those supremacists where only your belief, your faith should be given. Should be given credence. Tomorrow you will say, and I think a large number of people do argue this point. One second. Danesh Saab, please. 1 second. Give me 30 seconds, please. It's not a question of law, sir. The law goes into the facts. They don't go into the realm of faith. Please understand. Okay, 1 second. Sir, please. That's not fair. Don't disregard another faith and their beliefs. That is intolerance. Of course you are. That is what exactly this particular law does.
Okay.
Let's be honest about it.
Bigger than
Sai Deepak. Okay, good. Sai Deepak, very quickly. First of all, this whole question of, you are being emotional, basing everything on faith and not facts, etc., number one. And number two, Sai Deepak, lastly, what do you think the center is inclined to do?
I think the center is perhaps playing safe at this point, is my honest opinion. Because this is the 3rd or the 4th time that the center was given a specific 2-week indulgence to file a response to all the petitions across the board. And you have to realize that it's not as if these petitions were filed a few weeks ago. Some of these petitions were filed early this year, sometime in March, April. Ever since, these petitions have been languishing. And on the last date of hearing, time was sought on behalf of the center. But I don't wish to comment on that beyond that, except to say that I think the center understands that this legislation cannot be protected. And when the union chooses not to file a counter to a petition challenging the vires of that particular legislation or the constitutionality of the legislation, then I would say res ipsa loquitur, the facts speak for themselves. That is the point that I would want to make. Just one more submission, perhaps you may want to consider this, just to perhaps add to Rizwan Bhai's point and to perhaps build on what Dr. Swami said, which I disagree with. See, some of the temples whose reclamation is being sought as part of these petitions, including the petition in which I represent, you have to realize that some of these petitions may not be birthplaces of deities, but they have been mentioned in scripture. Not just in so-called local scripture, but also as part of, let's say, the Vedas, the Puranas, so on and so forth. Now, how can we say that some of those places have lesser importance compared to those places which are celebrated as birthplaces or Janmabhumis?
Sure.
Right? And therefore, I don't think this is a distinction that is worth striking.
Yes.
Because I, as someone who comes from the south, I may believe that Chidambaram is more important than some other place. Okay? Just as Kamakhya would be more important for people from Assam compared to any other place in the south or the north. Kshir Bhavani may be more important for people in Kashmir than any other place. Amarnath may be more important for people in Kashmir than any other place for Kashmiri Shaivites. Therefore, considering that the Hindu Sanatana Dharma is effectively an agglomeration of sampradayas and traditions across the country, it is the right of each of these sampradayas to reclaim what belongs to them and what they hold dear. It is for nobody else to actually say, you can't ask for this in the name of peace. Because if it's a question of peace, then we are expected to give up everything. Then what is the difference between that position and the opposite side's position? That can't be the argument. If you want to make an exception for one, make an exception for everything. Otherwise, that distinction is the textbook definition of arbitrariness or unreasonableness.
Well, viewers, let me tell you, we are at a point of inflection. The Supreme Court is going to become the center of a massive debate that will unfold by the end of the month. 15 days the center has now to respond, and they've asked specifically for these 15 days. So I'm sure right now in the center itself, in government, in high government, there are many conversations going on about what position to take, and one just sincerely hopes that they take a position which is enlightened, which actually respects not the Congress version of secularism, but perhaps what we all believe is constitutional secularism. I just hope that that is where we are going to be in the next 15 days. But viewers, as I said, an important point of inflection, and let me tell you that tomorrow we are also going to have another very important point of inflection. Why? Because viewers, the Supreme Court is likely to announce its verdict on the petitions challenging the Karnataka High Court verdict banning the hijab in the state's pre-university classrooms. Now you remember, viewers, that the Karnataka government had decided to call upon all pre-university students to adhere to the uniform strictly, which meant that children who were coming in or youth who were coming into class with overt symbols, cultural symbols, could not do so. The hijab fell into that bracket, and a large number of young girls were asked to remove the hijab, which created a massive furor. Petitions were filed in the Karnataka High Court before a single judge bench. That bench referred it to a 3-judge bench. That bench came out and said that the hijab is not essential practice in Islam, and therefore Muslim girls going to pre-university must remove their hijab, not when they enter the campus, but only when they enter the classroom, and observe to the T the dress code. Viewers, that particular judgment created a massive controversy and massive protests erupted, and many people, viewers, said that this represented the saffronization of our judiciary. Some people used stronger epithets against the courts, and finally the matter reached the Supreme Court, where certain students filed appeals to say that the Karnataka High Court 3-judge bench verdict must be scrapped. Well, after a 10-day marathon hearing in the Supreme Court in the month of September, which witnessed the ecosystem building the argument that the hijab is a religious right, that it's a garment that lends dignity to women, and ultimately the decision to wear it must be left to the choice of the woman itself. Tomorrow, we are being told that the Supreme Court will pronounce its verdict. Now, the question is, viewers, since that will be really the final verdict, will it be accepted? Will it be accepted? There are some basic questions. If the Supreme Court upholds the restrictions on hijab in classroom, will the Muslim side still cry Islamophobia as it did when the High Court 3-judge bench passed an order? If the principle of uniformity is upheld, will the ecosystem accuse the Supreme Court of turning saffron and furthering the cause of Hindutva as they have done in the past? It's the second big question. The third question is, given viewers the message from Iran, can the hijab still be regarded as a badge of dignity as it is sought to be portrayed by lawyers who are arguing for the petitioners backing the hijab? Fundamental question, and I want to open this up, viewers, tonight, and I want to ask the question first of Muhammad Asif Suhail, a political analyst. Mr. Suhail, will the Supreme Court's word be final, or will you once again quibble about the Supreme Court and say, oh, this is representing once again the saffronization of the Supreme Court? Remember what people said after the Ayodhya judgment? Are we going to see a repeat of that? Suhail bhai?
Rahul, let's wait for tomorrow. The judgment has to come. I believe that the court of law, the judges will keep in mind Article 25 and give the judgment. It's not on the basis of anything what they have been shown. Let's wait for it.
I'm
See,
only asking,
it's not about
I'm
a
not
hijab.
talking about the judgment. I'm only asking you.
Suhail bhai, personal practice.
Suhail bhai, since you moved the court, since a large number of petitioners,
let it come. See,
no, 1 second. I'm only asking you.
Unless and until
Sir,
we read the judgment.
I'm not asking you about the order per se. I'm not asking you what the verdict will be or will not be. I'm only asking you to give an assurance that yes, whatever it is, against, for, we will accept it. How difficult is that?
That's what I'm saying. Unless and until I read the order, I cannot see. It's a matter of judiciary. It's not the matter of making a media trial or anything by saying
Sayyid Rizwan Ahmed,
accept or not.
Sayyid Rizwan Ahmed,
let's wait for it.
Why today are some people not even give us assurance that they will obey the law as set out by or interpreted by the highest court in this country? This makes me worried, because we know that some of these protests were infiltrated, according to the government of India, the NI itself, by some very hardline radical organizations affiliated to even the PFI, which is banned.
Yeah, thank you so much. See, I said the other day, maybe in your debate, that the ban on PFI, because it was a nuisance-making organization, it tells me something, that the government is coming out with new policies, new bills, which will be landmark and which will be radical. Number one. Number two, like I was in the debate with you, and I humbly made my submission that I really don't know that Act of 1991, how will the Honorable Supreme Court go about it, or the government, or how will they maneuver it? I humbly submitted. But here I say that under no circumstances, Rahul, under no circumstances whatsoever, the Honorable Supreme Court shall sanction hijab within the school premises. I am so sure about it, because once the Honorable Supreme Court finds hijab to be an essential part of Islamic culture and gives a green signal for the school, it will have a pan-India and a pan-society effect. Tomorrow there is a girl, she's in hospitality, she's working in a 5-star hotel, she's a Muslim. What tomorrow she will come up wearing a hijab, and once the Honorable Supreme Court says that it is an essential part of Islam, keeping the spirit, letter and spirit of the Constitution, the management shall not be able to ask that girl to take off the hijab, maybe a receptionist, maybe an air hostess. So the Honorable Supreme Court will not let it spill over pan-India, pan-society, and spill it over in pan-campus, pan-school. The campuses, the education will be communalized. I bet on it today that tomorrow the Honorable Supreme Court is not coming in favor of hijab.
Well, we can't obviously preempt the Supreme Court, but yes, we have seen, viewers, what is happening in Iran, where the state, which is of course a state that is a religious one, there, and a theocratic state therefore, there, if you don't wear the hijab, because it's ordained, you see what will happen to you. We've already seen the cases of certain women being killed for resisting this, and there is no question of choice then left. Lokesh Jindal, the Congress has talked about choice, Priyanka Gandhi Vadra has talked about choice, yet you never questioned those who got up in the Supreme Court and said, let's make this, or let's interpret it, overturning the Karnataka High Court that said this is not an essential feature of Islam. You never supported the Karnataka High Court, but you went along, as you did in the past, even in Shah Bano's case, to support the more hardline conservative elements at the risk of perhaps endangering millions and millions of women. Why would you do that, Mr. Jindal, when your party is led by a woman who talks about empowerment, choice? Why would you throw them into the hands of theocrats?
Rahul, it's not fair to compare India with Iran, because India is
Sir, you are comparing, you are wanting to do it, you've gone to the Supreme Court, at least people from your ecosystem, certain, one second, you can't get away with this, sir, every day. You can't. You are the ones who are saying that this should be like it is in Iran, in other Muslim countries. You have quoted an essential feature. You are wanting to make, you are wanting to draw those comparisons in court. You say it is a, one second. What did you say? You said, or at least those people said, and this is very important, hijab is the identity of Muslim girls. Hijab does not disturb public order. Hijab is a symbol of dignity for women. Look at Jindal, you are backing these arguments.
See, Rahul, we have the Digambars who take decisions so as to give away clothes. We have the Sikh religion where the turban is essential. So in India, there is a different way of life that is taken up voluntarily by people.
Sir, आप क्या बोल रहे हैं? Sir, please, let's not today. Sir, these are not defining. Even the Karnataka High Court has said it's not a defining feature. Sir, please,
why are you draw the line? Sir, Harvey Cox clearly says that secularism is in peaceful coexistence. You cannot be selective with respect to a particular religion, that only this religion will not be allowed to practice or will not be allowed to be practiced. Now,
this is the Congress talking. This is the Congress talking that brought in the Places of Worship Act 1991. Very quick, Mr. Ahmed wants to, very quick. Rizwan Ahmed wants to counter you. Yeah, Rizwan Ahmed wants to counter you, and I want to bring in
10 seconds.
Karan Verma right
10
after.
seconds. Mr. Lokesh. Mr. Lokesh, as a Congress representative, do you subscribe to this idea that a girl wearing a skirt should be allowed in a madrasa? Do you subscribe to this idea? What do you say about it?
See, please do not compare a skirt with that of hijab. You are drawing wrong parallels altogether. You cannot compare skirt to that of what are you comparing a hijab with that of a skirt? On what
Sir, we are talking about choice. We are talking about choice, which is an argument that you have been throwing around. Your party leaders have been throwing around.
Listen, 10 seconds.
No. Priyanka Gandhi Vadra talked about the bikini.
The best of convent schools. The best of convent schools in this country are allowing skirts. The best of convent schools in this country, for God's sake, don't make a skirt a power dress. Don't make skirt a pervert dress. What are you talking? What are you speaking?
And Mr. Ahmed, let me also say, one second, Jindal bhai, 1 second, Jindal bhai, 1 second. It is Priyanka Gandhi Vadra. You're talking about skirt. She brought in the question of bikinis. Have we forgotten?
Priyanka
Karan Verma.
Madam stated
Exactly,
was, let
exactly.
it be the choice, let it be the decision taken by the women.
Karan Verma.
Who are
Karan
the
Verma.
males who
How
are-
can there be choice
It's
if it becomes an essential feature of your faith? Then it
Rahul.
will be the patriarchs that will determine it, and people will not be able to even go out of their homes without it. And we've seen it in Iran. And when people say, oh, India is a secular state, let me tell you, viewers, that a secular state can only protect you once you're outside your house. But they can't determine what various patriarchs might actually impose on you within the four walls of your house. They may threaten you with excommunication. They may ban you from leaving the home if you want to exercise choice. And that's what's happening in Iran. Why are we blind to this and deaf to this message and the visuals that are coming in from there? Karan Verma, would you like to respond to the Congress tonight?
You know, Rahul, both Mr. Asif and Lokesh time and again mentioned Article 25. What they forget is, and it's been set very clearly in precedent after precedent, whether it's the Shiru Math case, Sabrimala case or Triple Talaq, and it goes back to Ambedkar's speech on 2nd December 1948 that only essential features shall be considered under Article 25. Now, what are the 5 pillars of Islam? They are Shahada, prayer, zakat, hajj and fasting. Hijab, veil, this doesn't come under the 5 pillars. And the Karnataka High Court, the order, Rahul, it mentions 2 things very clearly. One, this does not come under Article 25, which is very clear theologically also. And Article 19, which is the freedom of expression, it is not absolute. It is subject to reasonable restrictions, which are the restrictions of the institution. Hence, I am 200% sure, and I second Rizwan Bhai, that tomorrow the verdict is going to uphold the Karnataka
Well,
High
let me
Court
tell you,
order.
viewers,
we cannot have.
we are not going to preempt what the Supreme Court is going to do.
Only valued, unfortunately.
These
when
are views.
people start losing
Sure.
it, as in Iran.
Sure, I understand. Look, I understand. We might all
Yeah, these are
here
views.
sit
These
and
are, of course, views.
second guess. You're entitled to do that, but of course the Supreme Court, viewers, has a mind of its own. It's going to apply its own mind. We're not preempting, we're not trying to force or push or extract any particular order from the Supreme Court. Just to say that tomorrow will be a major day, viewers, a major day, and I'll take a break here. Coming up, the news hour. stories on the show tonight, viewers.
After political storm over Aam Aadmi Party's Gopal Italia video calling Prime Minister Modi neech, Aap leader was seen abusing Hindu devotees in a fresh video. In a big setback for the Aam Aadmi Party, Punjab and Haryana High Court quash FIR registered against former Aap leader Kumar Vishwas and BJP leader Tajinder Bagga. After Tamil Nadu's CM M.K. Stalin, Kerala CM Pinarayi Vijayan writes to PM Modi against Parliament Committee's recommendation to make Hindi compulsory in higher education institutions and civil service exams. Pro-Kannada organizations defaced Rahul Gandhi's Bharat Jodo posters in Karnataka's Chitradurga, demanding changing Hindi language in posters to Kannada. 4 to 5 Hindu workers linked with RSS were attacked by a group of Muslims in Karnataka's Haveri. About 20 people have been taken into custody over the attack.
The most pressing issues, the most informed minds, free and fair exchange. Converse India with Rahul Shivshankar.
आपको सब फिल्म स्टार ही चाहिए मथुरा में।
नहीं हेमा
कन्हैया जी ने भक्त चाहिए जी कल रात की सावन का बिकम। सांसद बनना चाहेंगे उसको तो आप बनने नहीं देंगे। आप दिमाग में सबको ऐसा डाल के रखेंगे फिल्म स्टार ही बनेगा। आपको सब फिल्म स्टार ही चाहिए मथुरा में।
नहीं हेमा
कन्हैया जी ने भक्त चाहिए जी कल रात की सावन का बिकम। बहुत अच्छी बात है।
आपका क्या विचार है इस बार? आप
मेरा विचार क्या मैं बताऊं? मेरा विचार भगवान के ऊपर है। लॉर्ड कृष्णा विल डू इट।
मैं तो देश की सेवा के लिए ही पैदा हुई हूँ और मैं देश की सेवा करना चाहती हूँ। और क्यों नहीं हमारे मोदी साहब, हमारे प्रधानमंत्री जी चाय बनाते बनाते प्रधानमंत्री जी पीएम बन सकते हैं, तो मैं बॉलीवुड में काम करते करते सीएम क्यों नहीं बन सकती हूँ? डेफिनेटली मैं बनूंगी। आप सबका आशीर्वाद चाहिए। तो 2024 में अब आप मुझे चुनाव लड़ते हुए देखेंगे। किसके अपोजिट? ये सरप्राइज है।
Ladies and gentlemen, the Gyanvapi case has put the spotlight back on the contentious Places of Worship Act of 1991, a law that puts a cut-off date to reclaim Hindu places of worship. To be specific, this 1991 legislation prohibits conversion of any place of worship and provides for the maintenance of the religious character of any place of worship as it existed on the 15th day of August 1947. The legislation has been challenged on the ground that it bars judicial review, which is a basic feature of the Constitution, and imposes an arbitrary and irrational retrospective cut-off date, and abridges the right to religion of Hindus, Jains, Buddhists, and other religions. But the centre's lawyer has revealed his own thoughts on the 1991 law. When asked by a bench headed by Chief Justice of India, UU Lalit, whether he thinks that the 1991 Act was covered in the Ayodhya judgment that came just 3 years ago, Solicitor General Tushar Mehta said it was not covered, hinting that the verdict, Ayodhya verdict, didn't quite uphold the validity of the Places of Worship Act. Ladies and gentlemen, you would remember that while delivering the Ayodhya verdict in 2019, the Supreme Court referred to the Places of Worship Act and said that it manifests the secular values of the Constitution and strictly prohibits retrogression. The Hindus say that Kashi and Mathura must be exempted from the Places of Worship Act. Listen in.
Findings and the judgment so far as the Places of Worship Act is concerned in Ram Mandir case is an arbiter finding, and that has no bearing value, and that's not a judgment in rem, and it's not a binding precedent so far as the finding on Places of Worship Act is concerned.
Since they made one exception, that is Ram Janmabhoomi, they can make 2 more exceptions, and after that there can be no more exceptions, because all 3, Ram Janmabhoomi, Krishna Janmabhoomi, and Kashi Vishwanath, were actually where it is a site-specific temples were there.
सॉलिसिटर जनरल से पूछा था कि आप इस कानून के बारे में आपका क्या कहना है, क्या ये राम मंदिर में कवर होता है? सॉलिसिटर ने कहा कि नहीं, ये राम मंदिर में कवर नहीं होता है. हमारा ये कहना है कि इस पे सुनवाई डे टू डे होनी चाहिए.
But the opposition sees a communal plot in the reopening of this case. Listen in to the objections.
It is digging crime of the past for the present's utilization. Now, because of BJP want to create an that's communal fashion, communal division, and create an anti-minority hatred in the country. Hate is the order of the day now. To establish this new policy of RSS and BJP of running the states, they want to whip up these things. I think this is very bad.
So that brings me to the legitimate question we are asking on the NewsHour tonight. The question really is, has the centre dropped a massive hint about its position on the Places of Worship Act, and does it indicate a clear path for Kashi and Mathura? That's the question we're asking on the NewsHour. Hashtag Hindu Rights Matter. That's the hashtag and the debate on the other side.
You're watching the NewsHour at 9. Debate number 1 on Times Now. Super Prime Time.
And joining me tonight, Ishkaran Bhandari, advocate, also with me Subhrashta ji, author and anchor of The Churn. Also joining me Sushil Pandit, Kashmiri activist. With me Majid Haidri, activist. Atikur Rahman, Islamic scholar. Tehseen Poonawala, political analyst. But my first question goes to senior advocate joining me on the show tonight, Mr. Sanjay Hegde. Mr. Sanjay Hegde, I want to get your sense. Where do you think you stand on the issue of the Places of Worship Act? Because it's a contentious issue which has been raised yet again, and it talks about the context of raising this entire issue, which is the Places of Worship Act, which questions have been raised about how could it be retrograde and look at 1947 August 15th as a cutoff date, when along with the Ram Janmabhoomi, it was the Krishna Janmabhoomi as well as the Kashi, the Shankar temple there, that was being contested by the Hindus, and Subramanian Swamy and people like him have been saying that if you made an exception in one case, make two more and then end the story. Is there a point there?
No, the question is who is to make the exception? Why do you want courts to do your dirty work for you? If one parliament passed a law, another parliament can pass another law. Today there is a government with a majority in parliament. What prevents this government from passing a law in parliament? You drop the act altogether, change the act altogether, and the government of the day did not even file an affidavit in today's matter. It was when they did not file an affidavit that the court asked the Solicitor General for his personal opinion. Look, we have said it in the Ayodhya judgment that, the Places of Worship Act is an affirmation of the solemn duty which was cast upon the state to preserve and protect the equality of all faiths as an essential constitutional value, a norm which has the status of being a basic feature of the Constitution. It imposes a non-derogable obligation towards enforcing a commitment to secularism under the Constitution. It preserves non-retrogression as an essential feature of our secular values. This is what the Ayodhya judgment held. Now, maybe it was part of the judgment, maybe it was obiter, but an obiter is also binding on smaller benches of the Supreme Court.
No.
You can get rid of this, just one, let me reiterate the point. You can get rid of all this court proceedings by just passing an act in Parliament. Why don't you do it?
All right, but the other point of view can be that the judgment in the Ayodhya matter was a separate judgment. It was not related to the Places of Worship Act. Also, the Supreme Court precedents also show that observation made that are not necessarily relevant to the immediate issue at hand are not binding. Are not binding because the debate or the hearing hasn't concentrated on the pros and cons of that particular judgment. It was related to another matter, so not enough attention has been paid possibly to the Places of Worship Act.
So the point is, lawmaking is Parliament's domain. Interpretation of the law lies with the courts.
Okay, so isn't this an issue of interpretation then? Isn't this an issue of interpretation then? Because the Ayodhya verdict was not about the Places of Worship. Ayodhya verdict was different from the Places of Worship Act. So then if you say it's binding and it was said in the Ayodhya judgment, then it's a matter of interpretation.
Even the obiter of 5 judges, and that was a unanimous judgment, is binding on smaller benches. If you want to say that it is obiter not binding, you need a larger bench of 7. But instead of getting through all these legal gymnastics, the simpler route is to amend it in Parliament. And you have the power to do it. Do it.
Well, so Ishkaran Bhandari is the issue of which is the simpler step, and therefore should the government use that, or is this the issue of interpretation of the law as it exists today?
Let us put it what the step is all about. Of course, Parliament has its own powers, everybody knows, but equally a citizen in this country has the fundamental right to go to the Supreme Court to enforce his or her fundamental right. So let us not try to exclude the power of the court to constitutionally examine a law. Second point, let us be very clear, exclusion of judicial review, which is being done in this case under the garb of secularism, is the very thing every other person would object normally if any other law did that. And that debate has been long settled that you will not exclude judicial review. Let us come to the third part, which is very important, and which is this. What does this law do in effect? This law in effect says you could have a title, you could have the evidence, you could have all the documents, but under the garb of secularism, In fact, I think it will not be an exaggeration to say this law makes Hindus second-class citizens in their own country, that they will not, even if they have title, facts, evidence, be able to approach a court of law, because Parliament, for certain considerations, certain vote bank considerations, if I may say so, deems that we will deny you access to court. So all this act says, or all the challenges say, is that this act, if it goes, what will happen? People will have access to justice. They may win, they may not win. The courts, the title suits may come to a conclusion that you do not have a title. They may come to a conclusion that you do not have a case which will proceed. They may come to a conclusion that you don't have evidence. So why are we so determined to exclude evidence? Why are we so determined not to have cases go on, which is the logical, rational expectation in any democracy? And lastly, I would only say this much. When a dispute is not directly before the Honorable Supreme Court, Ram Janambhoomi had a clear-cut exception in it, then it was an obiter, and that obiter is not binding. The challenge, that is why notice has been issued, and I think that obiter will not be binding on the court. They may come to a decision that they uphold the constitutional validity. They may come to a decision it is not constitutionally validated, but the obiter will not come in way as per me.
Well, so let me ask Tehseen Poonawala. Tehseen Poonawala, the basic issue here, without getting into legalese, is why should one community not have access to the courts to interpret their rights? It's just a question of rights. Today it is the Hindus, tomorrow it could have been some other community, and you know, they would say, I have a problem, but this law that came in 1991 was enforced without a debate in Parliament and had a cut-off date of 15th of August 1947. I just want to ask you, do people of this country who have an objection to this not have the right to go to a court?
There are 2 points out here that I would like to make. Number one, that of course everyone has a right to go to court, in this case under Article 32, and seek recourse, legal recourse. However, the respondent in this case, the central government, has not responded, has not put an affidavit down. It doesn't matter what Tushar Mehta ji says orally in the court. What matters is what is on affidavit, and the central government is running with the hare, hunting with the hound. Now let me answer your question specifically that Sanjay tried to answer, but let me get a little bit more into details. I take objection to 2 words. One community is being cheated. I will come to that in the second part. But in your introduction, you said an arbitrary date of 15th August 1947, as has been put in this petition before the Most Honorable Supreme Court of India. 15th August 1947 is not an arbitrary date. It is the date India got independence. It is the date we became a democracy. It is the date we celebrate our independence. Therefore, Parliament in its wisdom, with or without a debate, as is your allegation or the allegations of the petitioner, Parliament in its wisdom thought 15th August 1947 should be the right cut-off date to end all past disputes except Ram Janambhoomi issue. Now to come to the next point of the argument that you are making. In my interpretation of the Ayodhya verdict that was put up by the Honorable Supreme Court and the 5 judges, the POW Act 1991 has been held akin to the basic structure of the Constitution. So Sanjay Hegde is right. This will have to go to a 7-judge or a higher constitutional bench. Now, Ishkaran is right. Let it go before it. We'll see what the outcome is. But you can be pregnant or not pregnant. You cannot be half pregnant. Therefore, the union government has to put an affidavit or remove it in Parliament. You cannot have half a stand of the union government saying we want to remove the act orally to Tushar Mehta, but not act in Parliament or in the Supreme Court. That cannot happen. You'll have to take one stand.
Well, yes, that is a fair point, and Subrashta ji, the government will have to take a position, and 31st October is by when the government has to take a position and file their affidavit in the court. But is this only about that limited fact? Is this only about one community? Because there are Muslims and non-Hindus who have their places of worship which have been destroyed or converted before August 15, 1947. So just by making this a Hindu law or a law desired by one community, are we limiting the import of this law? Because if it is revisited, it gives rights to others as well.
Yes, Navika ji, I would have taken your argument if the Hindus or the dominant group of Hindus would have been advocating for righting the wrongs of history, lock, stock and barrel in a very comprehensive situation. But I don't think that's the case. It's a very specific civilizational question with regards to three temples. Ayodhya, which has been settled, it's Kashi and Mathura now. I think these are the only three temples with which lot of civilizational pride, value has been ascribed to, and I think the Hindu community has very in a very articulate fashion has stuck to this point of view. So I don't think this really opens a Pandora's box as you would as you would claim. Now, with respect to the Places of Worship Act, I think a very important point to note is that places of worship are different from places of prayer. What the whole interpretation right now is with regards to places of worship. Now, with respect to the Hindu community, let me tell you, we cannot pray just anywhere. There are specific places of worship that we go to. Whereas in other communities, you can pray just anywhere, which is fine. I mean, so I think this becomes extremely important, and I agree with you. I think the government should take a position. I think places of worship, the word worship and prayer, they should be delineated. The constitution should absolutely define what worship means, how is it different from prayer, and I think it will settle a lot of questions and a lot of confusion that has been there with respect to this act and with respect to a lot of other issues.
Well said on that. Let me get in Mr. Atikur Rahman. Atikur Rahman Sahab, Subhrashta I think puts it very beautifully. She says this is not about all places of worship. There can be temples in hundreds of other places. She talks about only three which have a civilizational value for Hindus. And they, after the sorting out of the Ayodhya issue, now there are two other issues, which is Kashi and Mathura. So she says that this is a limited fact, this is a civilizational, cultural as well as religious importance issue for the Hindus. It's not about reopening a Pandora's box, and therefore there should be enough seriousness with which this demand, you can say, or desire of the Hindu community should be looked at from a constitutional and legal perspective, as well as from a civilizational and citizen right perspective. So Atikur Rahman, I want to ask you, did the people who made the law in 1991 use a fake umbrella of secularism? Because what is secular to others is possibly not secular to the Hindus. And is this now an outdated definition that we are seeing being addressed through the courts at this point?
Well, Navika ji, so the beauty of the argument is, are we witnessing the Hindu awakening or the Hindutva awakening? The bigotry which was committed in the 16th century in the absence of a constitution and a human rights charter, the same bigotry is being committed by the Hindutva awakening in the 21st century in the presence of the Constitution of India. With all the human rights, and the hashtag becomes on times now, the hashtag is Hindu Rights Matter. Look at the contradictory, this thing. From where to where we are becoming. 16th century bigotry getting repeated in the 21st century in the presence of a Constitution of India. Second important point is, the people of India, Navika ji, are eagerly awakening the formidable presence of the Modi government, changing, amending this aspect of 1991, insecular, unsecular, whatever you might call it, change it, amend it. Please live and let live. Let the people of India have a scientific temperament. What is the guarantee? Beyond it, after Kashi and Mathura, Subhash ji, beyond it, there won't be any Hindutva awakening.
आपको दिक्कत किस बात से है?
Don't shout.
People,
We can hear you.
I mean,
Can I
people
make-
are going through the
Navika ji, may I
legal route.
respond?
People are going to courts through the legal route. So why are you saying that this is Hindutva awakening, or is keeping quiet about their own rights something that is not allowed in this country? Where is this objection coming from? Coming to you, Subrashra ji, Ishkaran raised his hand first, then to you, and then I'll get in Sushil Pandit.
Ji, the very basic, let us be very clear. What is being said? Bigotry was done in 16th century, bigotry is being done now. If bigotry was done, justice is being done now. Let us be clear on the concepts. Secondly, where does it stop? There is an old legal maxim, fiat justica raut caelum. Let justice be done though heavens may fall. Not to do justice will be continuing of the 16th century bigotry, which tried to enslave a civilization, and setting it right is the basic need of the civilization to do in 21st century, to set all disputes at rest.
Historical wrongs cannot be corrected in this ugly fashion, sir.
Historical
wrongs.
Not ugly fashion. Going to court is not ugly fashion. Ugly fashion is barbarians invading, plundering, breaking, and using them to create footsteps, breaking idols, carrying them off. That was what was bigotry. What is being done, even though it's a majority community, it is only going to court to say, please and please allow our prayer of us being able to pray at our holiest sites. If you have a problem with that, then that is your problem. But Bharat needs that, and Bharat shall have it.
Well, Subrashra ji, let me read out a statement made by Mr. Mani Shankar Iyer on the floor of the Parliament. This was in 1991. He says, Mr. Chairman, sir, Uma Bharti ji told us when she had visited Varanasi and saw a temple and a mosque together, a feeling came to her that the temple had been demolished. She considered it to be a disgrace to Hinduism. According to her, a Muslim king had built a mosque here. There is only one difference between her and myself. To what she thinks a sign of servility, I take that thing as a symbol of secularism. Don't you think this really defines the politics that has ensued on this entire issue?
Navika ji, there were 4 points made on your show, and I think it needs a befitting response, because Atikur ji tried to spread false and fake information right here on a national channel. First of all, I don't think the government, I mean, this was Mr. Hegre's prime contention, that the government has really not taken a position. So what Mr. Atikur Rahman says is that the government is trying to amend the 1991 Act by perhaps bringing in a legislation. That is not the case, Mr. Atikur Rahman. The court has directed the government to take a position and explain its position by October 31. So that was fake news deliberately that was being spread by you. Point number 2. When you make this false equivalence of what happened in 16th century and today, do you even have a sense of what you are saying? How many Hindus have you seen barge into a mosque and say that this is a place of worship? With respect to a civilizational question like Kashi and like Mathura also, Hindus have been patiently waiting. We have been very quiet, and we will be quiet, and we will fight a lone legal battle if that may be, and that has been done and proven in case of Ayodhya. We never tried to demolish any structure in order to, present our point of view. So please take your words back. You cannot compare the barbarity of 16th century with what is happening today. Yes, there is advocacy going on, and advocacy will be loud, will be vociferous, will be articulate. Raise your arguments, raise the quality of your arguments, not your voice, Atikur Rahman. And stop spreading misinformation.
No temple was demolished. No.
Yeah, so Ayodhya is settled. So please let's not go back there.
No
Ayodhya is settled by the very courts. With whom you have a lot of, under whom you have a lot of,
so you are proved wrong.
Perhaps you repose a lot of faith. So Ayodhya is settled. What are you trying to say? Are you trying to say that what happened in Ayodhya? Are you trying to say that Ram Janmabhoomi is invalid now?
Kindly refresh your memory.
I am not confused. You were trying to create a confusion by lying on national television that the government is trying to amend an act. There is no legislation in place.
Now.
There is no legislation.
Well, Ayodhya is settled, and that is not the issue of contention. I want to ask Sushil Pandit. Sushil Pandit, amongst the many things which are objections by the petitioners, one of the objections is that this 1991 Places of Worship Act is applicable all over India except in Jammu and Kashmir. Now, on this alone, what about the legal standing of the Places of Worship Act? Apart from the other objections of the cut-off date, about the fact of civilizational questions of Kashi and Mathura, where do you think this is leading? And, you know, today we are hearing Atikur Rahman Sahab as if, you know, this cannot be done, this can't be done. Well, the Chief Justice of India has asked the government to submit its affidavit on the floor, you know, with the Supreme Court of India. So what are we talking about? Who's going to determine the rights of the petitioner? Mr. Atikur Rahman or the Supreme Court?
Yes. Thank you, Navika, for having me on your show, and good evening to all your viewers and panelists. First of all, I was very happy to see some progress in this conversation when I heard Atikur Rahman say that there was bigotry of the medieval times. And earlier in the montage, Hanan Mullah said the crimes committed in the past. So thank God there is at least acknowledgement, because till now we have heard flat denials that nothing of this sort happened. At least there is some progress and some acceptance of guilt. That's number one. Number two, very interesting proposition by learned counsel Sanjay Hegde, who says what prevents government from making a law. I completely agree with him. The government of the day in 1991, in its wisdom, created a completely unjust, unreasonable and arbitrary law on a rebound after 1991 events that happened in Ayodhya. Are they constitutional? Are they valid? Do they infringe on the rights of others? Are they equitable? Now, these are the issues that courts have always examined with respect to other laws. And indeed, it's not my place to remind him that courts have set aside unjust laws in the past. I can give him examples. Father of Mr. Chandrachud, who's going to be our Chief Justice, himself had set aside one of the laws. He was one of the first ones to set aside the law with Bihar, which was about takeover of land, you know, the Land Reforms Act in 1975. So legislators' right is not overriding. The courts have to sit in judgment over constitutionality. And if they hold something unconstitutional, they are within their rights to set aside those laws. And number 3 point, as far as this argument that please give us, kindly give us Kashi and Mathura and then we will forsake all our claims, is completely bunkum. I don't know who gave this right to whoever, that my Kali temple in Srinagar, which is now called Khanka-e-Maula and also variously called Shah-e-Hamdan, is to be retrieved. My community worships on the outside wall at the banks of Vitasta, Jhelum. It is humiliation to worship at the steps, which is the boundary wall of Khanka-e-Maula, because we've been evicted from there. Likewise, Bhojshala. Who gave the right to give away Bhojshala? Who gave the right to give away Baba Budangiri? The shrine which is in Karnataka, on which there is a great deal of consternation. There are similarly various other extremely sacred sites which we need to retrieve, and we need to retrieve agitating our right as a peaceful community in this day and age where we are a constitutional republic. And it is the duty of the courts. They can't keep pushing the ball in government's court, in the legislature's court. Judiciary has to serve its own responsibility, and indeed governments and legislatures also. We cannot fire from each other's shoulders. We have to take our responsibility and set these things right. There is no time bar on injustices of the past. These are indeed civilizational issues. They are as relevant today as they were then.
Well, Majid Hydari, you want to respond? Sushil Pandit has many of his rights taken away in Kashmir. There are a few that he still wishes to fight for. Can you take away the right from him and people of his community?
Malika Saiba, this controversy reminds me of Baba Bulle Shah's famous couplet. It's in Punjabi, though every Indian cannot understand Punjabi, but I feel they understand the essence of his couplet. It says, Masjid thade, mandir thade jo kuch thenda. Ik bande da dil na thavi, Rabb dilan vich rehda. The issue is not of Places of Worship Act of 1991. The point is that BJP is trying to hypnotize a section of its vote bank through a perception that Hinduism is witnessing its renaissance since 2014. It's not about Astha. It's about vote bank politics, BJP's agenda of 2024. It has nothing to do with Astha, because otherwise were Hindus not existing in the country for the last 70 years, or were my Hindu brothers not here for the last 30 years since when this law came into force? No, this is not about Astha. This is certainly not about that. It's only about vote bank. And then one more important point. This
my friend, before you proceed further, yes, Hindus existed, but do you know, calling yourself a Hindu was almost done apologetically in this country? and then Renaissance, or the pride that people are fighting for today, is the pride that is important to them. So whether it is one political party or another, the question here is about the right of people of a certain community. Why would you want to take away that right? Hands are going up. Coming to you, Sanjay Hegde, but Ishkaran Bhandari first. Ishkaran Bhandari objecting.
Existence without rights, without dignity is violative of Article 21. We are supposed to be happy that Hindus exist, but let me just give you two examples. Afghanistan, Sanatan Dharma was 7 lakh in 1970s, finished. Kashmir, where you will find much better statements by Sushil Pandit ji. What happened to Hindus and Sikhs in Kashmir? A genocide, a continuous genocide over the centuries, and a genocide done in the independent India. So let us please be very clear. We are not to be thankful that we exist and we get squeezed out. We have to exist, we have to flourish, and we have to reclaim what is ours, because injustice,
but Ariji, you are in the majority, you live in majority, you have been majority since the Muslim
My friend, there cannot be an argument which says, and Tehseen, I want to ask you, can there be an argument which says, अरे इतने सालों से तो तुमने claim नहीं किया, अब तुम्हारा कोई हक नहीं है claim करने का? What is this? I mean, is there a cut-off date? Is there a cut-off date when people can actually, raise their rights? Yes or no?
I am actually for the person. Sanjay bhai, I'll just be very brief. I'm actually for the first time in agreement with Sushil Pandit bhai and even with you, ma'am. First time. And I'll tell you why. I think why this Kashi Mathura, as the other spokesperson, as the other panelist on your show said, I think we should put every single issue. Why limited to 16th century? I think we should go back 10th century, 8th century, 7th century, BCE, or before time. I am not against it. I think this is what India should do. I think rather than discussing how India can become an economic superpower and how we can empower our kids, I think we should go back. And I want to ask one question. I want to leave it for your audience to think before I end. Today, we are saying one community continuously. Obviously, the dog whistle or the cat call is that maybe Hindus have been discriminated. Then I take that with humility in front of you. May I ask, tomorrow if the Jain community says our temples were also demolished, say, by a Hindu king, then we go back into time there, say tomorrow the Hindu community thinks the Jain.
Subrasha, of course Jains can also fight. This is not a Hindu-only law. This is not a Hindu-only law. So why are you, if you're talking about dog whistle of a particular kind, why are you limiting it? Yes?
No, absolutely. Let's go back to 4th century, 3rd century. Please. I absolutely agree with you.
Subrasha, respond to that argument.
I find this argument about economy. I find this argument about economy that let us discuss this and not that because, our economy is more important. Well, with respect to every government or state government, we have so many different ministries and departments. It is not as if a woman and child development ministry is working, the finance ministry stops working. There's ministry, fine, there is a whole new sense of revival with respect to Ministry of Culture, but that doesn't mean Tehseen Poonawala cannot go and lobby for whatever economic reforms he wants with the government. He can continue to do that. He shouldn't comment on civilizational concerns. He should stop coming to debates which discuss issues of culture and policy, polity. He should just focus on economic concerns. And I'm pretty sure there is a whole, community out there with respect to India Economic Forum and all of that, which discuss only issues of economy. So things can go parallelly. Only if you want things to run, people who are really passionate about this cause are talking about it. And why just Jain community or a Buddhist community? Even Muslims, if they want, they can, start doing that. But they would not, because they have something called the Waqf board, which Hindus don't. When partition happened and when Muslims came to this country, they had something called the Waqf board to actually take care of their properties. We Hindus did not have any board of that sort in Pakistan. Tomorrow we cannot go and claim our specific places of worship in Pakistan. So please understand that there are
I'm running out of time. I'm running out of time. The last comment to Sanjay Hegde. I'm running out of time. Last comment to Sanjay Hegde.
See, the last comment is simply this. What Parliament has done, Parliament can undo. Parliament has the power. Do your job. Why get the courts involved? As far as constitutionality is concerned, all that is looked at is, number one, do you have the power? Number two, does it violate any fundamental rights? Number three, did you come in time? This is an act of 1991. It has stood for nearly 30 odd years now. We keep changing our laws very frequently. Do your job, Parliament. Take your calls.
Well, I'm sure the government is hearing you, and maybe they were just waiting for your encouragement. But having said that, may I just say that the power to decide on the constitutionality is also with the Supreme Court of India. Why can petitioners not exercise their right to challenge this very constitutionality? What is so sacrosanct about the Places of Worship Act of 1991 that you can't even question it in the Supreme Court? What happens is anybody's guess, or the bench that will hear the matter and decide. But just about questioning it, does it call for lessons to be taught to the government on how they can change the laws? I'm sure governments of the day know their rights and their duties. We leave it at that. Thank you very much to all my panelists for joining me on debate number 1. On the other side, the wars for Delhi Chief Minister Arvind Kejriwal seem to be never ending for the moment. With back-to-back setbacks, the Aam Aadmi Party government is facing trouble on virtually every front. The latest blow is after the Chief Information Commissioner wrote to the Delhi LG claiming that the Delhi government failed to implement the RTI Act of 2005 and that the act had been reduced to a lame duck act. The CIC has said that the Delhi government was stonewalling information and there was high level of corruption in various government departments. Let's listen in to the CIC.
Actually, I have attached 16 cases with my letter. Each and every case is a story. When it comes to stonewalling, legitimate information which has impact on the appellant's life and property. There's one gentleman who lost his wife in COVID case in a hospital. They're not sharing papers with him. It's a very serious matter. And rather than making allegations against me, an ideal way of dealing with the situation is to look at what is happening. Another case is about hospitals not fulfilling their EWS obligations.
If that wasn't enough, the Aam Aadmi Party today also got a setback from the Punjab and Haryana High Court, with the court quashing FIRs registered by the Aam Aadmi Party against former party leader Kumar Vishwas and BJP leader Tajinder Pal Bagga in two separate cases. Remember, BJP leader Bagga was dragged out of his house by Punjab police in May for making alleged provocative remarks against the Delhi Chief Minister, but the court said that there was no proof his remarks could have caused communal hatred. Adding to the Chief Minister's misery was another Neta, Gopal Italia, president of the Aam Aadmi Party in Gujarat, who just 2 days ago called the Prime Minister Neech, and now another video of his has gone viral on social media wherein he's heard ranting against Hindus and asking women not to visit temples, claiming they are hubs of exploitations. Joining me on the debate tonight, Manjinder Sirsa, a spokesperson of the BJP. Also joining me tonight, Ishkaran Bhandari, advocate Abhishek Sudhir, spokesperson on Tiranga Shakha, and Dr. Akash Deep Muni, political analyst. My first question goes to Advocate Sudhir. And Advocate Sudhir, two big setbacks. Tajinder Pal Bagga, you know, the way the Punjab police came knocking on the doors and dragged him out, you know, it just shows that sometimes following the law might be better, because otherwise courts can actually come down heavily. And both Kumar Vishwas and Tajinder Pal Bagga today walk free. Where does that leave the law and the Aam Aadmi Party?
Well, Navika ji, I really appreciate your question. The courts should come down heavily when the law is broken. That's what Justice S. Muralidhar of the Delhi High Court did on Anurag Thakur and Kapil Mishra in the aftermath of the Delhi riots in February of 2020. Justice Muralidhar ordered the Delhi police to register an FIR against these leaders, and in a midnight order, Justice Muralidhar was transferred to the Punjab and Haryana High Court. And Justice Muralidhar is currently the Chief Justice of Orissa High Court, and just a few days ago his name was cleared by the Supreme Court Collegium, but the Union government has refused to transfer Justice Muralidhar as the Chief Justice of the Madras High Court. So I can tell you, Navika ji, I'm a member of the bar. I make this statement with the utmost responsibility. There is a fear amongst the judiciary. If you pass an order against the people who are leaders from the ruling party, the union government will come down heavily on you. They will ensure that your career never progresses. So there is a chilling effect that is running to the judiciary.
You are saying judges of the Punjab and Haryana court were compromised, scared, whatever, and that is why this order has been passed? Well, you know, Ishkaran Bhandari, now questions being raised about the court which gave the order.
That is what you're saying.
What else did you say?
Don't put words in my mouth.
I can replay what you said. I can replay what you said, Advocate.
I am saying, okay. Let me give you an example.
No, I don't want an example.
You made an allegation.
You said
let me count.
There is fear.
Now,
so it clearly means Ishkaran Bhandari, he is referring to fear which led to this judgment by the Punjab and Haryana court. Which means what?
I'm not saying that. Let me give you, you owe me 20 seconds to
No, I don't owe you any.
I
don't owe you anything. You made your statement in the first opening remarks that I gave you the opportunity for. You've tied yourself up in knots.
I don't want to participate.
Well, I don't
if you're not giving me 20 seconds, if you don't want to give me 20 seconds, I'm not participating. I'm not participating.
You
just apologize.
That's blackmail. That's blackmail, but you know, choose whatever you want to do. Ishkaran, did you hear that or did I only hear it?
Now, Vikajan, you can play the clip again. I think he said there is fear.
Can we just take out the clip? Can we take out the clip?
An advocate is saying that on national television, he should apologize or he may be in difficulty. That's a free, sound legal advice to him. Doesn't want to take it, it's his choice. The judiciary, of course, may feel it's not worth its time to react to such comments. Please give me 20 seconds. But let us be very clear. Two things he said.
Give me 20 seconds.
Midnight transfer of Justice Muralidhar.
Please give me 20
seconds. He, as an advocate, should know transfers happen via the collegium. So I do not know what aspersion he is trying to cast. Those are decisions of the collegium.
Then why is his name not being cleared?
Process under
why is he not being cleared?
Secondly,
the collegium has recommended his transfer to the Madras High Court.
All right.
The collegium has recommended his transfer to the Madras High Court. Why is the name not being cleared this week? Answer the question. The name of another judge has been cleared. The name of Navika ji, please let him answer this question. The name of another judge has been cleared in the collegium this week. Why has Justice Muralidar's name not been cleared?
He's answering.
Why
are you so agitated, my friend? He's answering. He's answering. 1 minute. Hold on.
Because the judiciary is under attack.
I think he should calm down and apologize for his statements on the judiciary. It's nothing to do with me or anybody on the audience, but your comments on the judiciary should not come from an advocate. If any citizen makes, you can still understand they don't know what they're saying. But an advocate saying that, I think, is very contemptuous. But anyways, be that as it may be, there is a settled procedure of transfer of judges, and that procedure.
I dare you take.
I don't have the time to waste on such.
I dare you.
1 minute.
File a contempt petition. Get the consent of the Attorney General.
Advocate Sudhir, you have a license.
You coward.
You have a license from the bar, but you have no license to hijack this debate. So just calm down. Just calm down. You had your say, and enough of time was given to you.
Why was Justice Muralidar's name not cleared?
Not the topic of debate tonight. Not the topic of debate, Advocate Sudhir. So I do not have to. I do not have to indulge you.
That is exactly the topic.
सिरसा जी बौखला गए हैं. एक तरफ कहते हैं कि हम कट्टर भक्त हैं, एक तरफ कहते हैं कि भाई मंदिरों में मत जाया करो. What is going on? You know, RTI information not be shared. There is the issue of the Punjab and Haryana High Court, and then there is Italia. Do you think they are surrounding themselves with lot of bloopers?
नहीं, डेफिनेटली नाविका जी, जो हमें आज समझने की जरूरत है, द मोस्ट इम्पॉर्टेंट पार्ट इज कि अरविंद केजरीवाल जी ने कहा क्या था और किया क्या. ये एग्जैक्ट लाइन वो कहकर पंजाब में सत्ता में आए थे कि जो पंजाब पुलिस नजायज मुकदमे दर्ज कर रही है, बेकसूर लोगों को जेलों में बंद कर रही है, हम उन मुकदमों को, पर्चों को खारिज करेंगे, हमें मौका दो. पिछली सरकार, अकाली दल हो, कांग्रेस, उन सब ने ब्लेम किया और ये सच्चाई भी थी नाविका जी. बहुत सारे मुकदमे पंजाब में दर्ज हुए. पर शॉकिंग ये रहा कि जिस दिन अरविंद केजरीवाल जी मुख्यमंत्री बनते हैं, तेजिंदर बग्गा तो चलो बीजेपी का आदमी था, दूसरा तो उनका कुमार स्वार्थ उनका अपना साथी था और उसने कोई पॉलिटिकल पार्टी ज्वाइन नहीं की. उसने आपकी आइडियोलॉजी के खिलाफ, आपने जो जाती हैं कि उसके खिलाफ विरोध किया और छोड़ दिया. कोई राजनीतिक मंच उसने अडॉप्ट नहीं किया. इन स्पाइट ऑफ दैट आप अपने साथी को जेल में डालना चाहते हो. इट इज जस्ट लाइक दैट. जो पहले हुक्मरान करा करते थे, तुगलकी फरमान जारी किया करते थे, इस लाल किले से तुगलकी फरमान जारी हो जाता था कि हमारे रिश्तेदार को जेल में डाल दो, को अपने पिता को जेल में डालता था, को अपने भाई को जेल में डालता था. ये वही मानसिकता है कि आप अपने साथियों को जेल में डालो क्योंकि वो आपके खिलाफ आवाज उठा रहे हैं. अब हाई कोर्ट को भी आज मैंने देखा, अरविंद केजरीवाल जी का और उनके साथियों का एक फिक्स ट्रेंड है. जो भी उनके सामने आए, आप उसको पार्टी का दलाल कहो, आप उसको बिकाऊ कहो, चाहे वो हाई कोर्ट के जज हों, चाहे वो जुडिशरी हो, चाहे वो इलेक्शन कमीशन हो, चाहे वो इंफॉर्मेशन कमिश्नर हों, या वो पॉलिटिकल पार्टीज हों, या वो लेफ्टिनेंट गवर्नर हों, या वो देश के राष्ट्रपति हों. मैंने देश में दूसरा ऐसा आदमी नहीं देखा जिसको संविधान के किसी भी चुने हुए नुमाइंदे पे विश्वास नहीं है और खुद झूठ बोलने के अलावा कोई काम नहीं कर सकता. अब हाई कोर्ट ने ये स्पीकिंग ऑर्डर दिया, ऐसा तो नहीं कि कोई स्टे दिया, क्वेश किया है और क्वेश करते वक्त ऑर्डर दिया है. क्यों दिया भाई, आप बताएं. इसमें कोई देश विरोधी काम ही नहीं है. आप कैसे देश विरोधी इसको बोल रहे हैं? किसी आदमी ने अपनी भावनाओं को व्यक्त किया, ज्यादा से ज्यादा आप उसको हेट स्पीच कह सकते थे, लेकिन देश विरोधी कह के मुकदमा आप कैसे दर्ज कर सकते हैं? दूसरी तरफ एक पॉलिटिकल आदमी विपक्ष में है, वो पक्ष की बात कर रहा है. वो क्या कह रहा है कि आपने कहा था मैं 24 घंटे के अंदर गुरु ग्रंथ साहिब महाराज की बेअदबी करने वालों को जेल में डाल दूंगा. तो अब वो पूछ रहा है कि आप झूठे हैं, आप बेईमान हैं, 24 घंटे नहीं पूरे हुए क्या? अब इसमें आप किसी को जेल में डालने की बात करेंगे, इसको मुकदमा डालें, सैकड़ों पुलिस वाले दिल्ली में आए, उठा के ले जाएं. आज तो क्लियर है कि जो कुछ कर रहे थे अनकॉन्स्टिट्यूशनल है. नाविका जी, अरविंद केजरीवाल जी से ज्यादा आज भगवंत मान जी के ऊपर लोग सवाल उठा रहे हैं कि आप क्यों चुप्पी साधे हुए हैं. और एक विषय नहीं है, आज उनके एक मंत्री ने कह दिया कि पाकिस्तान का बॉर्डर खोल दो. इलेक्शन जैसे जैसे पास आती जाएगी, ऐसे ऐसे एक पर्टिकुलर कम्युनिटी को अपने साथ जोड़ने के लिए उनकी वोट का तुष्टीकरण जो एक जिसको कहते हैं, उस सीमाएं सारी नांगते जा रहे हैं. मैंने आज से पहले देखिए, मैं भी राजनीति में हूं और मैं 50 साल का होने वाला हूं. मुझे अपनी याददाश्त में नहीं है कि ऐसा कभी किसी
women should not go to mandir. You know, is this?
Navika ji, if you give me 10 seconds more.
You know, no. With all respect, you had your say. Now let me come in. Now, Navika ji, one after the other, I'll answer on each and every facts. First, on the CIC's letter. Kindly give me time without interruption. The letter written by Uday Mahurkar, who is the CIC, his ideological inclination is questionable, as he has written the same books. Veer Savarkar, the man who could have prevented partition. Do you know, and center stage inside Modi's model of governance, marching with $1 billion, analyzing Modi's governance at midterm. No, let me complete.
One more dismissal. Come to the point.
I'll come to the point.
I have 30 seconds more for you. 30 seconds.
No, only 10 seconds. Only 10 seconds. Coming on to the Bagga story, I totally agree that, okay, let us agree that Bagga is right and Kejriwal ji has been wrong. If Kejriwal ji has been wrong, then Pawan Khera's allegation on Kejriwal, on false and filthy allegation, is also wrong. Nitin Gadkari ji's allegation on Kejriwal is also wrong, where he questioned himself on corruption. MP Ramesh Baduri's allegation on Kejriwal is also wrong. So, either all these allegations are wrong.
What's the point you're making?
The point I'm making is
Mr. Kejriwal has apologized. Mr. Kejriwal has apologized to Nitin Gadkari. He has apologized to the late Mr. Arun Jaitley. What are you talking about? But before I get you, Advocate Sudhir, you challenged me on the interpretation of your statement. I'll play it out because your soundbite, your face, no dubbing, live video as you spoke, being played out on the NewsHour.
I can tell you, Navika ji, I'm a member of the bar. I make this statement with the utmost responsibility. There is a fear amongst the judiciary. If you pass an order against the people who are leaders from the ruling party, the union government will come down heavily on you. They will ensure that your career never progresses.
Well, उठ गए आप, 20 सेकंड ले लीजिए, जवाब दे दीजिए, लाइट बंद, उठ गए एडवोकेट सुधीर, नो एक्सप्लेनेशन. Well, I gave you 20 seconds, sir. Well, that's how people run away when facts are put in front of them. Ishkaran, did I misinterpret or did he speak wrong?
These were literally his words playing out, and because he's a colleague at bar, I don't know where he practices, but he's Stripes advocate. That's why I recommended to him that if you have misspoken, please apologize. Don't try to defend the indefensible and run away. So
even that opportunity was not taken up. I don't know why. Always point fingers at those who have proven you to be wrong. Is that the only strategy that people who support the Aam Aadmi Party have? That's the question. Thank you very much to all my panelists for joining me on the NewsHour tonight. And thank you viewers for joining in. Have a safe evening. Good night. See you tomorrow.
The NewsHour at 9 will be right back after the break. at 9. After political storm over Aam Aadmi Party's Gopal Italia video calling Prime Minister Modi niche, Aap leader was seen abusing Hindu devotees in a fresh video. In a big setback for the Aam Aadmi Party, Punjab and Haryana High Court quashed FIR registered against former Aap leader Kumar Vishwas and BJP leader Tajinder Bagga. After Tamil Nadu CM M.K. Stalin, Kerala CM Pinarayi Vijayan writes to PM Modi against Parliament Committee's recommendation to make Hindi compulsory in higher education institutions and civil service exams. Pro-Kannada organizations defaced Rahul Gandhi's Bharat Jodo posters in Karnataka's Chitradurga, demanding changing Hindi language in posters to Kannada. 4 to 5 Hindu workers linked with RSS were attacked by a group of Muslims in Karnataka's Haveri. About 20 people have been taken into custody over the attack. You were watching the News Hour at 9. Stay tuned.
Welcome, you are watching the News Hour Agenda, India's most loved primetime show at 10. I'm Padmaja Joshi. In battleground Gujarat, a fresh fight has now been reignited over the legacy of Sardar Patel versus Pandit Nehru. The issuers of Kashmir and both the Congress and BJP are eyeballing each other on the question of who left the Kashmir issue unresolved. The sparring between the two parties started with the Prime Minister's address in Anand. While paying tribute to the son of Gujarat, Sardar Vallabhbhai Patel, the Prime Minister credited him with ensuring the merger of princely states with India. Then, without naming Pandit Nehru, he blamed one person who could not resolve the Kashmir issue. Soon after, the Congress released a fact check quoting from a book by Rajmohan Gandhi. Its communication chief Jairam Ramesh said that it's the then ruler of Kashmir, Maharaja Hari Singh, who differed on the question of accession, and if anything, it was Nehru's friend Sheikh Abdullah who championed Kashmir's integration with India because of his respect for Nehruji. Then came a counter fact check or an expose by Union Minister Kiran Rijiju. He quoted from Pandit Nehru's own speech in Parliament to say that the Congress is peddling a historical lie that Maharaja Hari Singh was not ready to accede to India. That this lie has gone on for far too long in order to protect the dubious role, what Rijiju said is the dubious role of Jawaharlal Nehru. The issue is a contested one and has raised its head periodically, given how Kashmir, especially POK, remains a festering sore in India's history and on its conscience. So who today can claim Kashmir as a legacy and who is lying?
You're watching the News Hour at 10. Debate number 1 on Times Now. Super Prime Time.
All right, at the beginning, we are going to be quoting from actual sources which have been offered from both sides. So let's stay away from the rhetoric. That's a humble request to all the speakers. Let's begin. Sanju Verma, national spokesperson of the BJP, historian and author Hindol Sengupta, leader of the Congress Kamar Zaman Chaudhary. And my first question is to author Sanjay Jha, because what Kiran Rijiju has quoted is a speech by Nehruji himself, where he says, and I quote, "We made it clear that even if the Maharaja and his government then wanted to accede to India, we would like something much more. That is, popular approval of it before we took that step. We did not wish by some clever tactics to gain something on paper." How would you say, Sanjay Jha, that this does not bear out the allegation that the Maharaja was ready to be a part of India? It's Nehruji who left it hanging, and we have a mess on our hands.
Padmaja, very quickly, we are dealing here with history, and fortunately most of it is recorded. The problem is when political parties do cherry picking. Now I'll tell you why Kiran Rijiju has added, unfortunately, to the entire distribution of what I call as the BJP fake manufacturing news production. Simple fact is, and anybody who reads history will know, that Maharaja Hari Singh never wanted accession to both India and Pakistan. He actually wanted independence. That is the hard reality. We got to live with that. And the truth is that until, Pakistan obviously, being insecure and overreacting, because it was very much aware that Sheikh Abdullah did not like the Muslim League. He was extremely popular in Kashmir. And there was this whole fear that it is a majority Muslim state with a Hindu ruler. And we all know that there was, again, the Hyderabad problem that India was battling with. In the circumstances when the Pathan tribesmen from Pakistan, supported by the Pakistan military, when they went as close as to Srinagar, there was panic. And I think Lord Mountbatten's relationship with Pandit Nehru was well known. And I think that was one of the preconditions for getting Indian military support. And I don't want to get into details, but VP Menon went across, inspected the whole situation. And it is very important to point this out. This has got nothing to do with Sardar Patel or Pandit Nehru being on opposite sides. They were part of the same defense committee that took a call. Leaders can have a difference of opinion, but all of them had the national sovereignty as a priority. So eventually, Padmaja, just to wrap it up very quickly, the truth is that the instrument of accession was signed because that was a precondition to India supporting Maharaja Hari Singh's, Kashmir, and ensuring that it was not going to be ravaged and, completely destructed by the very violent forces from Pakistan.
Okay, Sanju Verma, instrument of accession was always something that Indian politicians, Indian freedom fighters wanted. Nehruji and Sardar Patel included. It's just that they had a difference of opinion on the details, which you are trying to now project as some great disharmony. Sanju Verma.
Padmaja, okay. I heard Sanjay Jha. Padmaja, I noticed one thing. You might think I'm making a mountain out of a molehill. I noticed you kept addressing Sardar Patel as Sardar Patel, but Nehru as Nehru ji. Anyway, coming to the more important point, I'll just say this. I think, there are two things, Padmaja, to this we have to understand. A, as Kiran Rijiju said, not only did, Nehru reject Maharaja Hari Singh's initial request for accession to the Indian Union in July 1947, because by then it was decided that, a formal declaration of independence was to be announced on 15th of August 1947. But even in October 1947, Nehru finally agreed on the 27th of October 1947 when he was pushed to the wall, and I'm reading out from an excerpt of Nehru's speech which he gave in Parliament on the 24th of July 1952, where he says that the appeals from the Maharaja for help and for accession to India could no longer be ignored, and after anxious consideration and to think out the implications, etc., we finally realized we could not say no to that appeal and that we had to go there to help them. I just want to ask, as Kiran Rijiju has rightly said, Nehru in his speech on 24 July 1952 kept repeating that, Jammu and Kashmir it's a special case. As Kiran Rijiju points out, what was so special about Kashmir? Also, Nehru repeatedly says that, let us not be tricked by some clever approval on paper. There is something much more that we need to discuss. What is this much more that Nehru wanted to discuss? But beyond Nehru's semantics, Jairam Ramesh has quoted Rajmohan Gandhi through your channel and through your show, Padmaja. I want to ask Jairam Ramesh, have you read history books of independent, pre-independent and post-independent India written by many historians? There are works of R.K. Mukherjee, R.C. Majumdar, Bipin Chandra, P.N. Chopra, K.R. Malkani. I have not read all of them, but I have read a lot of them. And the most interesting bit is this. When Jairam Ramesh not only wants to give disproportionate credit to Jawaharlal Nehru and to Sheikh Abdullah, but he tries to undermine Sardar Patel's achievements, because note what he has written at the end of his thread. He says Sardar Patel was okay with J&K, with Kashmir going to Pakistan, just like Junagadh decided to go with Pakistan. But I want to make a small correction here. Junagadh decided initially to go with Pakistan, but it was thanks to Sardar Patel via a mix of military offensive and diplomacy that finally Junagadh, which is modern day Kathiawar region of Gujarat, in February-March 1948, that finally became a part of the Indian Union. And thanks to Sardar Patel, just 10 seconds Padmaja, thanks to Sardar Patel, that under Operation Polo, also called Operation Caterpillar, the erstwhile state of Hyderabad finally acceded to India, despite the erstwhile Nawab of Hyderabad, Mir Osman Ali Khan, not wanting to do so.
Okay, so let me bring in a historian now that we are talking about issues of history, and to make it very clear, to call someone G and to refer to someone as Sardar are both supposed to be terms of honoring them and out of respect. So there is no disrespect intended to either. Hindol Sengupta, did Nehruji stand in the way of Maharaja Hari Singh acceding? Did Sardar Patel push for it and was thwarted, or does the truth lie somewhere in between?
Thanks, Padmaja. As the only person in your panel who's actually written a biography of Sardar Patel, may I just say that the truth is far more complex than any of these people are trying to make it sound. The truth is, for most parts, before Maharaja Hari Singh acceded to India, for most parts, Maharaja Hari Singh and the Kashmiri Pandit community were in direct communication with Patel, and they had grave concerns about what would happen to them under Sheikh Abdullah, and indeed what exactly were Sheikh Abdullah's dealings with Pandit Nehru. All of this is well documented in the letters and notifications of Sardar Patel. Now, the point here is that it is true that Sardar Patel's main concern was Hyderabad for a long time. But once the Junagadh incident happened, Sardar Patel is on record saying that we will defend Kashmir no matter what. That, we keep talking about, and I even tweeted about this, Kiran Rijiju mentioned this fateful day in October 1947, when the final decision to send the army to Kashmir takes place. Bakshi Ghulam Muhammad, the aide of Sheikh Abdullah, who actually owes allegiance completely to Sheikh Abdullah, has a clear notification in his diary where he notes what happened that day. And he says that there was an air of complete irresponsible despondency and nobody wanted to take a decision, including Sheikh Abdullah, Pandit Nehru, Lord Mountbatten. Finally, the man who took the decision to send the army to rescue Kashmir, fight back against the invaders, was Sardar Patel. All of this is documented. Nobody can deny this. This is documented evidence. To suggest that Sardar Patel callously wanted to give away Kashmir is a false hope. The truth is more complicated. It is true that Pandit Nehru had a particular affinity for Kashmir, indeed had a particular friendship with Sheikh Abdullah, and Sardar Patel had a particular friendship with Maharaja Hari Singh. This had been going on for a long time. I want to conclude by saying one thing. Kashmir was a bone of contention between these two men, and I always say these two men were very close, but this was a great bone of contention. So much so that before Gandhiji's assassination, Kashmir was the point which broke these two men to such an extent that they both wanted to resign from the first government of India. All of this is also well documented. So let's take the whole thing in perspective.
Absolutely. And that's the reason why your voice is very important. That being said, to defend the legacy of Pandit Nehru is one thing, but to try and run down Sardar Patel and say Qamar Zaman Chaudhary that he was ready to give away Junagadh he was ready to give away Kashmir till the point that Junagadh happened. And that is when suddenly he had a renewed interest. Why would you want to insult one of our top leaders to defend the other? And they were both congressmen. It's not like Sardar Patel was of the BJP.
No, Padmaja, you have... the basic point is that here whatever we are discussing here, we are trying to twist history to suit a particular political agenda out here. You cannot idolize Sardar Patel and vilify Nehruji out here. The simple reason being there were 500 princely states in India, in pre-independence India, out of which Junagadh happened to be one, Kashmir happened to be one, Hyderabad was one, and very important aspect.
You cannot glorify Nehruji and vilify Sardar Patel.
It is never true.
Exactly.
No, we have to glorify both of them. They are
exactly, but that's not happening. Let me actually quote to you from what was put out by the Congress party as a fact check, where he has said, Mr. Jairam Ramesh has said, and I quote, Sardar Patel was okay with J&K joining Pakistan till September 13, 1947, when the Nawab of Junagadh acceded to Pakistan. And Hindol Sen Gupta, his biographer, says that is patently false. Sardar Patel was never okay with J&K being taken away by Pakistan.
No, you are misquoting facts from the piece, from the history, ma'am. You must first go to the fact that a States Department was formed in 1930, wherein Sardar Patel was heading that panel with Mr. Menon, VP Menon.
Sir,
he was acting as the secretary.
I'm not even going there about the States panel. I'm asking you a simple question.
Indian Union.
Mr. Jairam Ramesh has said, and I quote, Sardar Patel was okay with J&K joining Pakistan till September 13, 1947. Is that true, in your opinion?
That's a different issue altogether.
How is that a different issue to suggest
Nehru, Lord Mountbatten,
that Sardar Vallabhbhai Patel was callously giving away Kashmir to Pakistan is sacrilege?
Padmaja?
It was never the case like that. When the Maharaja Hari Singh wanted an independent state of Kashmir, it was Jawaharlal Nehru.
But if that is not the case, why would you put it out?
Kashmir to be part
why
of
would you
the
put
Indian
out
Union?
such facts which are not borne out by our lived history?
Exactly.
Why would you put out such facts? How many people would actually go back and check?
Entire accession history of these princely unions to the Indian Union, then why do you want to conveniently forget the role of Jawaharlal Nehru ji in amalgamating all those princely states? What about the Surma Valley of Assam? Gopinath Bordoloi ji, the ex-Prime Minister of Assam before pre-independence, he did not want the Sylhet district of Assam to be part of India. But it was Jawaharlal Nehru ji who went there. Abdul Muttalib Mazumdar, he was a congressman. They amalgamated the Sylhet district into the Indian Union.
Okay,
why do you
every
forget
political
that part
party,
of the
Sanju
history?
Verma,
When we
cherry
speak
picks
about
what
Kashmir,
suits their
it
narrative.
was always Jawaharlal Nehru.
Okay, I heard him, Padmaja. I heard him. Thank you. Padmaja, you know, whether we decide to quote Rajmohan Gandhi as Jairam Ramesh has chosen to do, or whether you want to believe what Sanju Verma says by quoting P.N. Chopra or Bipin Chandra, that is not material. As Hindol Sen Gupta said, there are some things which are either black or white, there is no grey. And I just want to tell you that the link which Kiran Rijiju has posted on Twitter and has Nehru's entire speech with respect to Kashmir and related issues pertaining to accession. Nehru also telegrammed Liaquat Ali Khan when this entire Junagadh controversy was spiraling out of control, where he said that we have pointed out to you previously that final decision should be made by means of either referendum or plebiscite. We would be glad to discuss this question and applied matters affecting Junagadh with representatives of your government at the earliest possible moment convenient to you. I am reading out ad verbatim from Nehru's telegram to Liaquat Ali Khan. The point I am making is Nehru was in the mood to actually have a dialogue with respect to Junagadh. He wanted a plebiscite. He wanted a referendum, despite the fact Padmaja, that Junagadh was a Hindu majority state then ruled by a Muslim from the Babi dynasty. Had it not been for Sardar Patel's military offensive combined with diplomatic offensive, Junagadh eventually in
Sanjay Jha,
this is not a question.
Sanjay Jha, it goes beyond Kashmir.
India.
Maharaja was
Sanjay Jha, let him respond, please.
Padmaja, there are history and we should not allow that to be distorted. So let me just tell you the critical point. Maharaja Hari Singh, and by the way, there are multiple historians and I have read many eminent ones in the past, so I'm going to quote them liberally. Maharaja Hari Singh was suspicious of getting himself becoming part of India because India was becoming democratic and India would be taking, not a very kindly, shall we say, predilection towards the princely states. And out there, everyone knows that as far as Mr. Jinnah was concerned, he was openly threatening Maharaja Hari Singh, and that is also on record. So basically, he wanted independence. He was not keen to be part of the Indian territory. Let's accept that. I mean, end of day, these were triggered events that forced his hand into signing the instrument of accession. Now, why I'm particularly disappointed with the BJP spokesperson here, and this needs to be said, that given the fact that this founders and many of their ideologues had zero contribution in India's freedom struggle, it's rich for them to come on a TV show and present a biased and a prejudiced perspective. And it's so incomplete and therefore your viewer will get confused. Let me tell you this, Padmaja, when there are different leaders of a political party, they all have a different opinion on that topic.
Okay, quick 20-second rebuttal, Sanju Verma. I want to bring in Hindol and Gupta after that. Quick 20-second rebuttal.
Padmaja, my limited rebuttal is this, that we, the BJP or the RSS does not need an integrity certificate from a suspended leader of the Congress party on what the RSS or BJP's contributions have been. My limited point is, it is publicly documented that Sardar Patel made an invaluable contribution in ensuring that 565 princely states and
fact, nobody is taking that away. But finally, let me ask you, Hindol and Gupta, is it as stark as that to say that the integration was done by Sardar Patel and Pandit Nehru did nothing at all, in fact, ran in the opposite direction? Is it as stark as that?
No, it cannot be as stark as that. No one with any real academic bent of mind would say it's as stark as that. However, please let me say this. No one with any real reading of the primary material would ever claim that anybody but Sardar Patel was at the forefront of bringing these princely states together. If you read Maniben Patel's diaries from that time, day after day, Maniben Patel notes how hour by hour different Maharajas, different princely states, their representatives, their divans were in regular negotiation with Patel. Many of these princely states would have perhaps never joined India or created real difficulty for India had it not been for Patel. Please remember, the only person that the princely states were really scared of was Patel. There's this famous story, Padmaja, and this is where, please give me 10 seconds to mention this. There was a famous Maharaja who put a gun to the head of Sardar Patel's emissary, who took the accession papers to him. And the emissary told him that, well, you can shoot me, but you still have to talk to the Sardar. And that's when he put down the gun and signed the papers. The only person a lot of these people were scared of was Sardar Patel. So you cannot deny, nobody can deny that Sardar Patel was the primary person who brought India together, all these princely states with British India, and without him, this task either couldn't have been done or would have been very bloody and messy. This is undeniable.
All right, let's just leave it at that. Let's have the historian take the last word in a debate about history, and it's been a very contested one. My bet is going into battleground Gujarat, this is going to get sharper, given that there are still many claimants to the legacy of Sardar Patel, the towering figure from Gujarat. Thanks very much, all gentlemen. Sanju Verma for joining me. In a big setback for the Aam Aadmi Party, the FIRs registered against former Aam Aadmi Party leader Kumar Vishwas, BJP leader Tajinder Bagga, based on Aam Aadmi Party's complaint, have been quashed today by the Punjab and Haryana High Court. Remember, an FIR registered against Kumar Vishwas for making comments against Delhi CM, alleging his links to separatist elements. The Punjab and Haryana High Court, while quashing the FIR, said the court's non-interference would result in miscarriage of justice. Meanwhile, in the case against Tajinder Singh Bagga that was registered over what Aap called fabricated and false allegations that instigated violence against Kejriwal, the court said that there is no evidence of his remarks causing any communal hatred and he is well within his right to protest as a leader of the opposition party. Remember, it is on the back of these complaints that the Punjab police had walked into the national capital and tried to grab Tajinder Singh Bagga. Operation that set off a fierce war of words between the two parties. Now, with the court setting aside both of these FIRs, is the Aam Aadmi Party in the dock for using its police for personal vendetta against political rivals?
जो कुमार विश्वास वाले मामले में है उसमें भी हाई कोर्ट ने ये कहा है और उन्होंने बड़ा अच्छा कोट किया है, जजमेंट्स को भी कोट किया है और हमारे जो नेहरू हैं उनको भी कोट किया है कि अगर डेमोक्रेसी में अगर आप इतना क्रिटिसिज्म नहीं फेस कर सकते तो फिर डेमोक्रेसी का कोई मतलब नहीं है। ये इंटेंट ऑफ द ऑर्डर इज दिस, और उसमें अगर आप इस तरह से जो कनेक्ट करने की कोशिश करोगे कि वो एक कोई स्पीच कहीं दी हुई और रोपड़ के अंदर 15-20 लोगों के ऊपर ऐसे किसी ने लगा दिया, पर्चे फेंक दिए, तो वो भी प्लॉजिबल नहीं है। 2-3 ग्राउंड्स पे कुमार विश्वास का केस भी बड़े स्ट्रॉन्ग वर्डिड जजमेंट के साथ वो भी FIR को क्वैश किया।
You're watching the News Hour at 10, debate number 2 on Times Now, Super Prime Time.
Joining us on the debate, Tajinder Singh Bagga, spokesperson of the BJP in Delhi, Namit Saxena, advocate on record, Supreme Court, Professor D.K. Giri, political analyst. My first question is to you, Dr. Piyush Joshi, political analyst. It seems that you've been called out by the High Court for what is seemingly an action of vendetta.
Good evening to all. I'll just start by mentioning that I am not official spokesperson of Aam Aadmi Party. I do support Aam Aadmi Party for the policies of healthcare and education. I must extend my congratulations to Mr. Bagga for getting relief in the cases. However, the option always remains of going to the Supreme Court with the Punjab government, but I think they should better let this case rest here and they should use their resources to serve the people of Punjab in a much more better manner.
So that's a great thought, but the point is it also needs to be answered कि अगर आप स्टेट की पुलिस का इस्तेमाल अपने पॉलिटिकल राइवल्स के खिलाफ एक्शन लेने के लिए करेंगे, then it becomes like a private militia, right? यही आम आदमी पार्टी जब सत्येंद्र जैन के खिलाफ केस होता है, they say that this is a witch hunt. Today you have been called out for a witch hunt. The Aam Aadmi Party has been called out for a witch hunt.
Look, if you are going to get into that, then I must expect the same from BJP for filing about 150 odd cases against various Aap MLAs and ministers, and Kapil Mishra should apologize for mentioning that 2 crore has been exchanged to Arvind Kejriwal.
But Dr. Joshi, every case has to be seen on its own merit. Today we are talking about the High Court basically saying that what was said was a freedom of expression. It was a statement of protest by Tajinder Singh Bagga. And for that statement of protest, उनके घर पे पुलिस आई, उनको घसीट के ले गई, उनके पिताजी के साथ हाथापाई की. If this is not a witch hunt, what is?
What I'm trying to say here, that's why I started by extending the congratulations to Mr. Bagga. But having said that, freedom of expression as adjudicated by the Honorable High Court, I respect the decision. But what I'm trying to say that one statement can be perceived in various manners. Punjab Police has perceived it in a different manner and went to the court against Mr. Bagga. And High Court has denied it. The option of going to Supreme Court is still rests with the Punjab Police. But I personally believe in my own personal capacity that they should spend the resources on the various problems facing Punjab.
Okay, Tajinder Singh Bagga, एक स्टेटमेंट को अलग अलग तरीके से इंटरप्रेट किया जा सकता है. ठीक है, कोर्ट को लगा कि देयर कैन नॉट बी एनी डेमोक्रेसी विदाउट फ्रीडम ऑफ चॉइस एंड फ्री स्पीच. पंजाब पुलिस को लगा कि आप भड़का रहे हैं.
नहीं, पंजाब पुलिस को नहीं लगा, अरविंद केजरीवाल को लगा। अगर पंजाब पुलिस को लगा होता, पंजाब पुलिस ने खुद से कोई एफआईआर की होती तो बात और होती। आम आदमी पार्टी के एक प्रवक्ता ने एफआईआर की, और मैं आपको बताना चाहता हूं जिस प्रवक्ता ने एफआईआर की थी, अभी 15 दिन पहले उनको इनाम मिला है और एक बोर्ड का उनको चेयरमैन बना दिया गया है पंजाब का। सनी सिंह आलूवालिया, जिनका मैं नाम ले रहा हूं, जिन्होंने एफआईआर की थी, उनको उस बोर्ड का एक बोर्ड का 15 दिन पहले चेयरमैन इनाम देके बनाया गया है। तो पंजाब पुलिस ने केजरीवाल के कहने पर एफआईआर की, ये मैं आपको बताना चाहता हूं। नहीं तो आप ये बता दीजिए कितनी एफआईआर होती है जो शाम को 4 बजे होती है और सुबह 4 बजे पुलिस दूसरे स्टेट में 50 पुलिस के साथ अरेस्ट करने चली जाती है। और एफआईआर के अंदर के आरोप क्या है? आरोप यह है कि अरविंद केजरीवाल ने एक बयान दिया था कि कश्मीर फाइल्स जो है फिल्म झूठी है, कश्मीरी पंडितों का नरसंहार झूठा है। उसका मैंने प्रोटेस्ट किया और मैंने अरविंद केजरीवाल जी को यह कहा कि अगर आप माफी नहीं मांगते हैं तो हम आपको चैन से जीने नहीं देंगे और तब तक प्रोटेस्ट करेंगे जब तक आप माफी नहीं मांगेंगे। जो कश्मीरी पंडितों का इतना बड़ा नरसंहार हुआ था उसको आपने झूठा कहा है। तो उसमें आगे की पीछे की लाइन काटी गई और यह कहा कि मैंने अरविंद केजरीवाल को जान से मारने की धमकी दी है। मतलब चैन से जीने नहीं देंगे, इसे जान से मारने की धमकी। अगर मैं कल को यह कह देता हूं कि आप चुल्लू भर पानी में डूब के मर जाओ तो मेरे खिलाफ अरविंद केजरीवाल जेल में डाल देंगे कि मैंने ये उनको सुसाइड के लिए प्रोत्साहित किया है। तो ये मुझे लगता है कि आज कोर्ट ने कहा है। और अगर चैन से जीने नहीं देंगे, ये तो एक कहावत है, ये तो आम बातचीत में बोलचाल की भाषा है। आप इसके अगर आप सोचते हो कि कई तरह के मायने निकाले जा सकते हैं, मुझे लगता है कई तरह के मायने सिर्फ अरविंद केजरीवाल और दूसरे लोग ही निकाल सकते हैं।
Just a quick rebuttal if you are allowing me.
Yes.
I'm just saying, अभी ही बग्गा साहब ने जो बोला उसमें ही उन्होंने दो चीजें ऐसी बोली कि अरविंद केजरीवाल जी ने कहा है कि कश्मीरी पंडितों का नरसंहार झूठा है। I don't recall him saying that. Okay, so this is the extrapolation of one particular statement. He might have said something about the movie Kashmir Files. He never said that कश्मीरी पंडितों का नरसंहार झूठा है। Now, देखिए प्रत्यक्ष तो प्रमाण की जरूरत नहीं। It's clear in front of us that the extrapolation of speech can lead to different meanings for different people, and it can be perceived in different manners. And we
But
have
sir, this is not just about perception. डॉक्टर जोशी, आपका एक परसेप्शन हो सकता है, आप डिसएग्री कर सकते हैं, टीवी पे आके डिबेट कर सकते हैं, पर आप पुलिस भेजने कुमार विश्वास को उठा ले, अलका लांबा को उठा ले, तेजिंदर पाल सिंह बग्गा को उठा ले, ये तो कोई आपका डिसएग्रीमेंट नहीं है ना, ये तो एक्टिव अरेस्ट है। और एक अरेस्ट जिसको आज कोर्ट ने सेट असाइड किया है। दिस इज नॉट अबाउट कि हम यहाँ पे डिसएग्री कर रहे हैं और हम डिबेट कर रहे हैं। टू यूज योर स्टेट पुलिस, दैट इज अ मच ग्रेवर ऑफेंस हियर।
देखिए इन बग्गा जी के कई ट्वीट्स भी रहे हैं। देयर हैव बीन मेनी ट्वीट्स इन द पास्ट व्हिच हैव बीन फाउंड ऑब्जेक्शनेबल बाय द पंजाब पुलिस, बट द ऑनरेबल हाई कोर्ट डिसाइडेड अगेंस्ट इट, सो फेयर इनफ। What I personally believe that we should not revisit those tweets again and again, because ultimately if we are going to revisit those tweets, then it's going to lead to another conflict again.
Sir, this is not about revisiting. Obviously, if you get a setback, let me read out to you what the High Court has said. Hold on a second. Being a political activist and official spokesperson of a political party, Professor D.K. Giri, as a shadow of the incumbent, it was well within his rights to make the people aware of the response of an opposite political leader. Democracy is all about informing the people and creating sentiments, and it would be an offense only if campaigning is full of hatred or there is an involvement in malicious activities or derogatory and vicious statements are made to gain political mileage. यहां पर एक आदमी कह रहा है मैं आपके खिलाफ प्रोटेस्ट करूंगा और मैं आपको चैन से जीने नहीं दूंगा, आपने उसको उठा के जेल में बंद कर दिया। और फिर आप बात करते हैं डेमोक्रेसी की, फिर आप बात करते हैं कि भाई लोकतंत्र की हत्या हो रही है क्योंकि सत्येंद्र जैन को जेल में डाला जा रहा है। ये तो फिर दिस इज अ डबल स्टैंडर्ड, राइट प्रोफेसर डी.के. गिरी?
Well, yeah, I will take a different. I'll take a different perspective. Let me tell you, as a student of politics for last 40 years, you see, democracy is not run purely on the basis of law. The latter part of your statement, the long statement that you read, is very correct. Unfortunately, we are full of malicious statements, hatred, and insightful statements as well in our public utterances. So, in a democracy, what is legal also is not moral. I'm making a strong premise. So there are three arms in our democracy: judiciary, executive, and legislative.
Sir, that judiciary is great. I'm not here to get a political science lecture.
Activism.
My point really is more straightforward. Professor Giri, hold on a second. ये एक ऐसी political party है जिसने अपने inception पे came on board and said things like सारे नेता चोर हैं, सबके सब मिले हुए हैं। उन्होंने एक लिस्ट बना दी सारे नेताओं की, कह रहे हैं कि भाई ये सबके सब चोर हैं, इन सबके खिलाफ सीबीआई का इन्वेस्टिगेशन होना चाहिए, इन सबको जेल में डालना चाहिए। पर उनके खिलाफ अगर कोई बोल दे कि मैं इनको चैन से सोने नहीं दूंगा, चैन से जीने नहीं दूंगा, आप कह रहे हैं ये तो मेरी हत्या की साजिश। आप लोगों को चोर बोल रहे हैं, पब्लिकली चोर, और कह रहे हैं कि ये करप्ट है, लिस्ट जारी कर रहे हैं। खुद के खिलाफ आप एक शब्द नहीं सुनेंगे। ऐसे कैसे लोकतंत्र चलेगा प्रोफेसर गिरी?
Yes, I'll give you the answer you want, but I was making a formulation for your audience. But as an anchor, you would like a direct answer, which will, which will sort of amuse your audience. I'll do that.
I don't want any amusement. I want a factual answer.
Not only Aam Aadmi Party, BJP as well. So no. Yeah, I'm telling you. So this is a political battles, and there is no political battles.
तो आप मान रहे हैं ना that for a political battle the police was used to pick up political rivals. And you're accepting कि ये political battle था, इसमें कुछ factual नहीं था.
It is used by every party. That is my point. It is used by every party. BJP is doing more than Aam Aadmi Party. Which party is not doing it? Tell me.
Okay, तजिंदर पाल सिंह बग्गा,
which state is not doing it?
आपकी पार्टी ने आम आदमी पार्टी के मंत्रियों का शोषण किया और अब वो आपके पीछे है। हर कोई करता है, says प्रोफेसर गिरी।
Correct. It's a tit for tat. You see, both are in a similar strategy. I cannot differentiate between Aam Aadmi Party and BJP. Tweedledum and Tweedledee.
अच्छा, tit for tat.
So how can I answer this?
But sir, lot tit for tat नहीं चलती है ना?
They are doing it in 2 states where they are in power.
You are reasoning it as if you are saying कि भाई किसी ने किसी का murder किया, उसको जाके छुरा मार दो, tit for tat. But that's not the way the law and least of all the government is supposed to function.
No,
this is, remember, the state government and the state police. These are not two sadak ka gunda. This is the state police which is being used for tit for tat, and you're saying it so casually. Tajinder Pal Singh Bagga.
No, I'm not.
मैं सबसे पहले तो धन्यवाद करता हूँ प्रोफेसर गिरी जी का कि इन्होंने
One at a time, please. Mr. Bagga, yes.
जी, मैं प्रोफेसर गिरी जी का धन्यवाद करता हूं। कम से कम उन्होंने ये माना कि बीजेपी ने किया था इसलिए उन्होंने किया। अब मैं आपको बताना चाहता हूं दोनों मामले। एक मामला वो था जो भ्रष्टाचार का था, जिसके ऊपर ईडी ने एफआईआर की, 2 साल 3 साल तक इन्वेस्टिगेशन हुई, उसके ऊपर गिरफ्तारी हुई। आम आदमी पार्टी लॉ कानून के तहत गिरफ्तारी हुई। आम आदमी पार्टी सभी के सभी कोर्ट गई और किसी भी कोर्ट ने भ्रष्टाचार के मामले को देखते हुए राहत देने से इनकार कर दिया। अब दूसरा मामला मैं अपना बताता हूं। मैंने उनके घर के बाहर प्रोटेस्ट किया, लोकतांत्रिक तरीके से पुलिस को परमिशन देके हम लोगों ने प्रोटेस्ट किया। उसके बाद एफआईआर हुई। 50 से 60 पुलिस वाले एफआईआर होने से 12 घंटे के अंदर दिल्ली के अंदर आए और मुझे उठा के बिना दिल्ली पुलिस को कानून को दिए जानकारी दिए उठा के ले गए। मुझे पगड़ी पहनने नहीं दी गई। मेरे पिताजी ने बोला तो मेरे पिताजी के साथ मारपीट हुई। अगर उनको लगता है कि दोनों मामले सेम है तो मैं उनको बधाई देता हूं। देश की जनता समझदार है और देश की जनता फैसला करेगी।
पीयूष जोशी।
I'm just quoting the same thing. What basis did Mr. Bagga have against saying that Mr. Kejriwal said Kashmiri पंडितों का नरसंहार झूठा है? Or is that statement malicious or not? Or can it affect political opinion in a mass of Kashmiri Pandits or not? When did Mr. Kejriwal say this?
Sir,
did he say it ever?
The Punjab and Haryana High Court has upheld.
Precisely. What I'm trying to say. Look.
Okay, let him respond. Go on.
Okay. I'm not talking about the movie Kashmir Files. I'm talking about कि कश्मीरी पंडितों का नरसंहार झूठा ऐसा केजरीवाल जी ने कब कहा, कृपया बताएं।
तजिंदर बग्गा।
अरविंद केजरीवाल ने दिल्ली असेंबली के अंदर, जब दिल्ली ये कश्मीरी पंडितों के नरसंहार पे फिल्म बनी, उन्होंने कहा इस झूठी कहानी के ऊपर मैं टैक्स फ्री करूंगा। इस झूठी कहानी, कौन सी झूठी कहानी, किस चीज के ऊपर वो फिल्म बनी है, किस चीज को उन्होंने झूठा कहा? और ये पहली बार ऐसा नहीं हुआ है। मैं आपको बताना चाहता हूं, अरविंद केजरीवाल इस मानसिकता के व्यक्ति है, मैं आपको बता रहा हूं। पहली बार उन्होंने इस प्रकार से नहीं कहा। जब बाटला हाउस इनकाउंटर हुआ, उन्होंने वहां जाके कहा था बाटला हाउस इनकाउंटर फर्जी है।
It is just
बाटला हाउस इनकाउंटर फर्जी है। मैं आपको बता रहा हूं, उनका एग्जैक्ट स्टेटमेंट बता रहा हूं। इस झूठी कहानी के ऊपर बनी फिल्म को मैं टैक्स फ्री नहीं करूंगा। तो कौन सी कहानी को वो झूठा कह रहे थे? वो कश्मीरी पंडितों के नरसंहार की कहानी को झूठा कह रहे थे, उसको कहानी कह रहे थे।
बेसिकली
उसी के बाद हमने प्रोटेस्ट किया, हमने कहा उसको माफी मांगे।
the main thing is that a cinema is a different thing and an incidence is a different thing. What Mr. Bagga is saying about Mr. Ahluwalia as well, it is a combination, it is a sentence which is, one is a fact, another is a fact, third is a fact, and fourth is an assumption. Okay, and that's how he is constructing that Mr. KG on
Sir,
Mr.
why are
Kejriwal's
we?
directive.
Okay, I have to admit I quite lost track of what your actual argument is, because this has already been settled by the court,
there are two parts
which
of
is
my
saying.
argument.
So there are no parts to your argument. You basically are going on and on saying, when did Mr. Kejriwal say this? When did Mr. Kejriwal say this? It has been made very clear by the High Court today that whatever was said cannot be seen as malicious or any call to violence, and hence to say that he was spreading enmity. Namit Saxena, what do you look at it as legally? Was there any basis to that case at all?
Not at all. This was completely baseless. This is not how criminal machinery can function at all in this country, is one. Second, in my view, this judgment is inadequate. I'll tell you why. Because this judgment does not compensate Mr. Bagga and Mr. Kumar Vishwas properly. See, the way Mr. Bagga and Mr. Kumar Vishwas, their custody was taken, they ought to have been duly compensated by the High Court. Their custody was completely illegal. The way they were arrested was completely illegal. The Punjab police flouted all settled norms in law, including, judgments way back from D.K. Basu, etc., till, as recent as March 2022. They violated all norms in taking custody of Mr. Bagga and arresting him. So this judgment is highly inadequate in this manner, that they ought to have, the High Court ought to have compensated him. Leave apart quashing, it had to be quashed. This is completely baseless, is one. Second, I must respond to what Mr. Giri said. If we go by Mr. Giri's political acumen, that that they can be tit for tat like this, the rule of law will go for a toss. This country is governed.
I didn't say that.
This country is governed by.
Exact words were tit for tat, Professor Giri. You said it tit for tat hai.
These are your exact words, Mr. Giri.
I didn't say that.
You
I didn't say that at all. You play back the record. What I'm saying is, I was commenting on the. Wait a minute. I was commenting on the behavior of the political leadership. Let me answer somebody. Wait a minute. Answer. Now give me the answer. Punjab police picked up Bagga. What did Haryana police intercept the Punjab police? What did they come into the picture? Is it not politics? Where is the role of Haryana police to intercept the Punjab police and send Bagga back to Delhi?
What? See, that is what the High Court has observed.
I was saying that there is no difference
I'm not sure. I'm not sure.
I did not get it for that.
Tejinder Bagga आपको respond कर रहे हैं. Tejinder Bagga आपको respond कर रहे हैं. Go on. Yes.
Wait a minute. I never said
इनको ये अगर एक जी गिरी जी के मैं सवाल का जवाब देता हूँ. शायद गिरी जी को शायद गिरी जी ने
I never said tit for tat.
गिरी जी बात सुन लीजिए. मैंने आपका सवाल गिरी जी मैंने आपका सवाल बहुत ही ध्यान से सुना और मैं जवाब देना चाहता हूं. उम्मीद है कि आप बिल्कुल अच्छे ठंडे दिमाग से उसको सुनेंगे. शायद आपने इसका देश का कानून पढ़ा नहीं है. उस कानून के हिसाब से अगर कोई भी एक राज्य की पुलिस दूसरे राज्य में जाती है तो ये उस राज्य की जो पुलिस है उसको सूचना देनी होती है. वहां का लोकल पुलिस स्टेशन का एक पुलिस ऑफिसर आपके साथ जाता है. आपको बताना पड़ता है आपके साथ कितने पुलिस वाले आए हैं, कितने के पास असला है, वारंट दिखाना पड़ता है. वहां पे जब आपकी पुलिस आई, पंजाब की पुलिस आई, ना उनके पास वारंट था, ना वो वर्दी में थे, ना वो लोकल पुलिस स्टेशन गए, सीधा घर आए और उठा के ले गए. जब मेरे पिताजी के साथ हाथापाई की और मुझे उठा के ले गए, कोई सूचना नहीं दी, मेरे पिताजी ने पुलिस कंप्लेन की, पुलिस कोर्ट के पास गई और कोर्ट ने ये सर्च वारंट जारी किया. उस सर्च वारंट के बिना के ऊपर हरियाणा ने रोका. शायद आपको देश के कानून का पता नहीं होगा, इसलिए आपको नहीं पता होगा. इसलिए मैंने आज आपको थोड़ा सा आपका ज्ञान बढ़ाने की प्रयास किया है. आगे भी कभी आपको इस प्रकार की जरूरत पड़े तो आप मेरे को सीधा पर्सनल फोन करके भी ज्ञान बढ़वा सकते हैं.
And Professor Giri, just the way the Punjab police acted, do you know, actually the most important part of what the court has said today is the way, the behavior of the Punjab police, where they have said, had the investigating agency of another state been given that much leverage, it would impact the federal structure under the Indian constitution, where every state has the right to maintain law and order within its own territorial boundaries. यहाँ पर दिल्ली में बैठ के तेजिंदर बग्गा ने कुछ बोला, सपोजिटली दिल्ली के चीफ मिनिस्टर के खिलाफ, और पंजाब की पुलिस आकर के उनको उठा के ले जा रही है. This will lead to a breakdown, sir, of the federal structure. You realize this is basically going to cause anarchy, where police are going to be used as private militia.
Absolutely, the court should pass a stricture against Punjab police and take them to action. It is one person versus
the government needs to answer.
I do not know the details, how many policemen came and how they caught hold of his hand.
Okay, Namit Saxena, is it only about the Punjab police behaving unilaterally?
Police or Bengal police or Haryana police? This is the police of our country. You are calling out Punjab police because it is under AAP. The police is our police. It is police any state. It belongs to Indian police.
But sir, the police cannot be misused by the state government.
Aam Aadmi Party is in government.
Let Namit Saxena answer. Is the stricture against only the Punjab police? Were they acting unilaterally, Namit Saxena?
They were acting definitely unilaterally. See, that is why this observation is extremely serious, and this observation must be taken by the High Court, must be taken, extremely seriously by we as a civil society. See, this is allowed to be done. One state's police can enter into another state without any territorial jurisdiction, without informing the local police, without following the procedure. See, in any case, due process of law is to be followed. And in fact, the Supreme Court goes to an extent of saying if something is to be done in a particular manner, it has to be done in that particular manner alone or not to be done at all. This case, in Mr. Bagga's case particularly, the way his custody was taken is completely illegal. There is no excuse, and saying that Haryana police, how did Haryana police did that? Why did this happen, etc. is of no consequence at all. What did
Mr. Bagga, do you think that there should be compensation to you and to others who were similarly booked after this judgment?
नहीं, देखिए हमें कंपनसेशन तो ऐसा कुछ नहीं चाहिए, लेकिन मैं सिर्फ एक सुझाव देना चाहता हूं भगवंत मान जी से। ये जो आप पंजाब पुलिस का दुरुपयोग कर रहे हैं, इसका सबसे ज्यादा नुकसान पंजाब को हो रहा है। जिस दिन मेरे को 6 मई को पुलिस अरेस्ट करने आई, ठीक उसके 2 दिन बाद मोहाली में पुलिस हेडक्वार्टर के बाद बम ब्लास्ट हो गया। लेकिन पुलिस कहां पे बिजी थी? आप सोचिए, मोहाली की ही पुलिस 50-50, 60-60 पुलिस वाले यहां पे थे। वहां पे आज लॉ एंड ऑर्डर की क्या स्थिति है? तो मेरा उनसे सिर्फ इतना सुझाव है, दिल्ली में अरविंद केजरीवाल और राघव चड्ढा जी के कहने पर अपनी सरकार को चलाना बंद कर दीजिए। आप पंजाब के लॉ एंड ऑर्डर को ठीक करने की कोशिश कीजिए। आपने पंजाब की जनता से वायदे किए थे कि आपने गुरु ग्रंथ साहब जी की जो बेदबी करने वाले दोषियों को 24 घंटे के अंदर जेल के अंदर डालेंगे। आपने ये कहा था कि पंजाब के अंदर 1 महीने के अंदर ड्रग्स की समस्या खत्म कर देंगे। अगर आप ये दोनों चीज कर लेते हैं, मेरे लिए यही सबसे बड़ी कंपनसेशन होगी।
All right, and it's not about Tejinderpal Singh Bagga or Alka Lamba or about Kumar Vishwas. It is about what is ethical for the police and the government to do, and serious observations made about the breakdown of federal structure by the High Court today. Thanks very much, all gentlemen, for joining me. Thanks for watching.
The News Hour at 10 will be right back after the break.
You can't.
The most pressing issues, the most informed minds, free and fair exchange. Converse India with Rahul Shivshankar.
आपको सब फिल्म स्टार ही चाहिए मथुरा में?
नहीं, हेमा मालिनी।
कन्हैया जी ने भक्त चाहिए ही राधे कल रात की सावन का
Watching the News Hour at 10.
After political storm over Aam Aadmi Party's Gopal Italia video calling Prime Minister Modi niche, AAP leader was seen abusing Hindu devotees in a fresh video. In a big setback for the Aam Aadmi Party, Punjab and Haryana High Court quashed FIR registered against former AAP leader Kumar Vishwas and BJP leader Tajinder Bagga. After Tamil Nadu CM M.K. Stalin, Kerala CM Pinarayi Vijayan writes to PM Modi against Parliament Committee's recommendation to make Hindi compulsory in higher education institutions and civil service exams. Pro-Kannada organizations defaced Rahul Gandhi's Bharat Jodo posters in Karnataka's Chitradurga, demanding change